26. I mean, pardon for mention, my lord. Item 19, my lord. I am for the opposite party. Interim stay is there. So let it come one chapter. I will highlight.
The opposite party seeks an adjournment.
Yes.
Yes. 19.
Page 4, item 27 to 40.
30 mileage item 30 may be taken up one any day next week because it is a POSCO compromising petition. Both the party were absent. So that and 30, 37 also same mileage. Any day next week mileage.
Next week.
30 and 37.
Settle, matter settled.
Yes, yes. A compromising petition affidavit has been valid because of the unable. They are not unable to come.
28 minutes after that is
20. Test matter.
item 39, my lord. I pray for after vacation, your lord. Fresh matter.
Fresh matter.
Fresh.
Page 5, item 41 to 51.
Let's see, item number 31. Praying for after that.
Fresh matter.
Let's see. 31.
Page 6, item 52 to 68. Page 7, item 69 to 77. Page 8, item 78 to 84.
My lord, item number 82. Can be taken up after vacation, my lord.
82.
Yes, my lord. Oblige me.
For 84, man. After vacation, press.
Fresh matter.
Page 9, item 85 to 91.
Item 88. There are so many defects are there. Let it be remove the defect and any other day.
You are for
Opposite party.
let him come. Tick karo.
No.
If it close. Yes.
Page 10, item 92 to 96. Page 11, item 97 to 105. Page 12, item 106 to 113.
Page 12 and 107, my lord, item number.
Yes.
There is no interim order, my lord, after vacation.
My lord,
The matter was posted for today, a compromise matter, and parties were to be present today, my lord. It has not come up.
Parties are there.
My lord, we had called them to contact, but matter was not.
Are they here
so we
today?
have- Since it was, we had called them yesterday, since it was not posted, so.
Let it
come
be
today.
Let it be tomorrow morning.
Yes, ma'am.
Tomorrow morning. Huh? First item. Tomorrow morning. First item.
my lord, it is CRLMC 15 by 92. It is compromise matter, but the court slip has been dated to 2/5/24. The both parties is come.
They are there.
Yes, my lord.
That will try.
So they are present in the court today.
Yes, my lord.
So list it today.
Mane
On the way.
on the way, he will come.
जेतल पहुंच गया कहे तो मात्र
No,
Let
it
it
has to
go.
be listed.
Huh?
What is the offense?
Offense on under the 354B and POSCO section 8.
Let it be tomorrow morning.
My lord, court ଆସିବେ ଆଜି
କୋଉଠୁ ଆସିବେ ଜାଗା
ଜଗନ୍ନାଥ ପ୍ରସାଦରୁ ବାହାରି ପଡ଼ିଲେଣି, ପହଞ୍ଚିବେ within 1 hour ପହଞ୍ଚିବେ. Specialist. After break.
Let it be. It was listed today, otherwise. Date
Yes.
was given. Date was given.
Mention in the post.
Oblige.
May I seek your lordship permission to mention this item, my lords? This is a criminal MC number 1645. This is against my lord in the matter where judgment your lordship had reserved. In the same matter, despite informing the trial court, another NBW has been issued against the petitioner, my lord. I have filed this application under 482, my lord. I'm only praying it may be listed tomorrow, my lord, because
Cancellation of NBW.
Please.
Cancellation of NBW. Give the number. Take it.
Number.
Give the number.
One criminal MC number 1645 of 2024. 1645 of 2024. Vidhu Bhushan Nayak versus State of Odisha.
Let it be tomorrow.
I am so grateful, my lord. Deeply obliged.
Yes.
Pardon to mention, lordship. The petitioner has filed two CRLMCs in challenging the interim compensation order. the opposite part number 2 has filed a vacation of that particular protection provided to petitioner in respect of that order. Matter may kindly be taken up expeditiously, Your Lordship. I provided the memo already. Much appreciated.
Beg pardon, my lord. I am mentioning one criminal appeal against conviction, my lord. It is a vigilance matter, the fresh matter, criminal appeal number 392 of 2024. 2-year
What is the
conviction.
sentence?
2 year,
Sentence?
Your Lordship. 2 year, my lord. RI for 2 year.
Fresh matter.
Fresh matter.
Fresh matter.
Appeal.
Appeal will admit only. Suspended.
Tomorrow will be difficult. Tomorrow will be difficult.
One second matter. Appeal admitted, sentence suspended. Let it be tomorrow.
Grateful, man.
Only
Grateful,
appeal
man.
admitted, sentence suspended. For 2 seconds. Yes.
I have a fresh admission.
Tomorrow I'll sit only for 1 hour. So that is the reason. Adjusting small matter we can, yes.
I have some one fresh matter.
Give it. Yes. One is pass over.
One lordship may, sorry lordship.
Yes.
She has come. She has requested me for passport. She has
Okay.
come.
Item 1 lordship, I have filed 4 sets of paper book. Lordship may already verified and
This is criminal appeal.
criminal.
What is the sentence?
Sentence 1 year.
One year? It is already admitted.
13(1)(d) and 7 of the.
It is already admitted.
Lordship.
The appeal is already admitted.
से early hearing पाई देइछन acceptance of paper book
Early.
I-
Paper, you have filed the
Paper
paper.
book already.
paper book accepted and list this matter after.
This matter. Include that in the cause list for next week. Whenever we get the time, we'll do it.
next week रे होई परिबनी hearing से आसु vacation पर आसु कारण सब CRLM से appeal गुडा सब जन दिया छै ना होई परिबा it will take more than 2 hours or 3 hours.
Why 2 hours?
नहीं कारण मु एटा मते तो फिर पढियो गुडा आसु छै
For
kindly understand my
preparing 2 hours, for argument 2 hours.
नहीं अपेयर माने प्रिपरेशन पाई कारण राति रे लिस्ट आसु एटा त आसु छुट्टी पर आसु जणा
We
हबो
will finish it up within 10 minutes.
ना सेटा दैट इज ट्रू किंतु सेटा आसु आफ्टर
And
वेकेशन
then you tell me.
After-
This is early hearing application, so
हां आफ्टर हियरिंग एटा 2018 लेट इट कम आफ्टर वेकेशन
include that in the cause list below the revision. Whenever it comes, I'll accommodate. Don't worry. Include it. Cause
Fix
list.
a date. Lordship.
फिक्स डेट कौन से ऑटोमेटिकली
Next week, it will be included in the cause list. Whenever I get time, we'll just. Okay.
Yes, yes. Paper book may be short. Registry directed to the registry.
Directed to the
Paper book
copy
may be
to
short to vigilance and standing
it's fine.
council.
Okay.
Item 2.
May I please, my lord?
Yes.
Appeal has already been admitted. I have filed 4 sets of papers for hearing, my lord.
The same order could be included. Same.
Here, let's say
Registry-
there is sub
I may be
item.
pardoned, madam. I may be pardoned. Registry may be directed to serve a paper book to me. And
It's a paper book to Mr. Sanjay Kumar Das.
Same is here also. So second sub item is there.
Sub item.
There I may.
Both the you have
minor,
filed
minor
the
may
paper
kindly
book.
No, Lord.
I have filed paper.
Same, because-
I have, there are 2 accused persons. One I have
And
filed.
the one paper book will be
One
separate.
paper book
Surprise.
separate.
Only thing, the copy may be sub on me.
Copy
That-
copy of the paper book will be shared with the council.
In the second
minor
item.
may kindly see sub item noting.
Noting.
Sub item noting may kindly be perused. Since 18/5/23, the appeal has been admitted, bail has been granted, fine has been stayed by the coordinate bench of this honorable court. It has again been indicated IA number 1230. Your lordship may kindly have a glance to the cause list. Sub item,
Yes.
sub item.
Yes, yes.
So that may be ignored.
That's right. That may be ignored.
Yes.
No problem.
No issues.
My lord, may I pray that item number 1, Mr. Niranjan Maharana, additional standing counsel name may be reflected. He has
Yes,
been
Mr. Narana is
entrusted.
here. He's here. He is here. No problem.
No, his name may kindly be reflected in the cause list, my lord.
Okay.
Mr. Niranjan Maharana, ASC.
Yes.
But I mean, pardon, it will be list, it will added in the list next week.
It will be added. Whenever we get time, we will see.
Well, obliged.
It is of the year 2023, my lord. 23 only. Your lordship will hear the year-old matters. 15 your lordship have already
23.
fixed.
Why are you worried?
But the
2003
out of
matters are
job,
pending.
the petition is out of job, that's why. It will take
out of
half
job.
an
आपको
hour,
conviction
it will take, it is it?
Out of job. Everybody is out of job.
I will try my luck, let it in the list, I will try my luck.
Okay, 2023.
Okay,
2015 matters are pending.
ତାଙ୍କର ଯେତିକି ଅଛି ସେ 15 ମସିହାର ଲିଷ୍ଟ କରିଦିଅନ୍ତୁ chronologically. Let it be hard. 15 ମସିହାର ପର୍ସୁ କରିବେନି ଯୋଉଥିରେ
ବାବା କେତେ ଅଛି ଆପଣଙ୍କର?
ଆଜ୍ଞା
ହଁ
15 ମାସ କେତେ ଅଛି?
ଟୋଟାଲ ଅପିଲ 300 ଖଣ୍ଡେ ଥିବ ଏଥିରୁ ଭିଜିଲାନ୍ସ 100ଟା ଖଣ୍ଡେ ଥିବ
15 ମସିହାର
ଆଜ୍ଞା ଦେଖିବାକୁ ସମୟ ଦରକାର ନୂଆ ଯିଏ ଆସିଲା
ନାଇଁ ନାଇଁ ପୁରୁଣା ମ୍ୟାଟର ଦେଖିବାକୁ ସମୟ ନାହିଁ ଆପଣ ନୂଆ ମ୍ୟାଟର ଦେଖିବାକୁ
ଯିଏ ଆସିଲା ଭିଟାମିନ ଏମଟା ଦେଲା ଏଟା ଆଗ ମୁଣ୍ଡରେ ପଶିଲା ଯିଏ ନ ଆସିଲା ଗଲା ରହିଗଲା କୋଲ୍ଡ ଷ୍ଟୋର ରହିଯାଇଛି
we'll see.
ନେକ୍ସଟ ୱିକ୍ ଆସ
We'll see.
Obliged, my lord.
Beg pardon, Your Lordship. Item 3, my lord.
Yes.
Your Lordship previously heard this matter and Your Lordship called for the CD in this matter also. What happened, my lord? Initially, on 11th February 2021, a FIR registered under 170, 417, 419, 384, 395 of IPC against unknown person, my lord. The complainant is a worker servant of Rashtrapati Bhavan, my lord. He visited the place Phulbani. Some person looted that person. Thereafter, my lord, on 23rd February 2021, the present petitioners are arrested because of the media hike and devastating news published, Your Lordship. After the arrest of the petitioner, my lord, the present complainant, my lord, voluntarily appeared himself before the learned court below and proved the petitioner's innocence, Your Lordship. Your Lordship may kindly peruse page number 51.
Yes.
51, my lord.
Yes.
The complainant himself submitted, my lord, I am the deponent in this affidavit, the informant in this case.
51, where are you reading? 51 is the proceeding.
My lord, CRLMC number 1659 of 2023.
How many petitions are there?
Two cases.
Two 482 applications are there.
Okay, 51.
51, page number 51 of CRLMC number 1659 of 2023.
Yes.
May I read, Your Lordship?
Yes.
That I am the informant in PS case number this and this. The same is numbered as city case number this and this. From the electronics and press media, it came to my knowledge that one ex-MLA of Phulbani constituency, Devendra Kaur, the present petitioner, with Srinivas Kaur, another petitioner, were arrested in my case by PS case number this. My FIR is unknown. So also in my statement recorded under 161 CRPC is also not disclosed the name of any of the assailants. Moreover, it is clearly mentioned that soon after arrival of police, the assailants were fled away from the spot. So question of identification of assailants at the scene occurrence does not arise at all. These accused petitioner were not present at the time of occurrence. These accused petitioner are innocent and falsely implicated in this case. It is the statement of the complainant, my lord. Basing on this statement, my lord, the petitioner released on bail. And my lord, in this case, the crucial aspect is that, my lord, the TIE parade not conducted, Your Lordship.
Where is the
On that ground, my lord,
notice was issued?
Notice not issued.
Oh,
Your Lordship may
issue
kindly
to
issue
opposite
notice
party.
to the
Opposite party number 4.
all the opposite parties. My lord, opposite party number 4 is the complainant, but other victims are also there, my lord.
No, only I want to see opposite party number 4.
Grateful, Your Lordship.
Notice to opposite party number 4. Mr. Ragada accept notice for opposite party number 1, 2, and 3.
Well,
1, 2, 3. Ready to go?
Grateful. Grateful.
Yes.
Both the cases.
Both the
Item 4.
Need to use that. It is with regard to that Factories Act case where my lord cognizance has been taken under section 92 of Factories Act.
Yes.
And my lord, if my lord will.
Who are you?
I am the occupier, my lord.
Occupier.
I am retired, my lord. I am a elderly person of 85 years old, my lord. Now, I am staying in Mumbai.
The earlier matter, my lord. One, my lord, case they are made the opposite party the complaint, my lord. In another case, my lord, 165, my lord, क्या करना है? केवल state court.
चलो second opposite party को
I will add the opposite party, my lord.
Okay, you do whatever the second matter court the
क्या करना है?
first matter tag कर दी सर.
Our data case अच्छी, समुदाय चार्टा case number दे दो.
नहीं, in your case, you are the occupier.
My lord.
What are the incident?
Incident is that, my lord, because of the mechanical failure of the machine, because it was a mechanical power machine, my lord, its hand got pulled and its palm got detached, my lord, amputated. The palm was amputated, my lord. So their entire thing is that there was no supervisor. There was no supervisor. Their entire case is that there was no supervisor.
You inform in time.
Yes, my lord. Form 18, my lord, may see. This is my.
Yeah, but how many hours you have informed?
My lord, immediately we have informed. We have immediately.
That's not the allegation.
And that too, my lord, allegation is not that only supervisor was not there. That is the entire thing, my lord.
How much compensation you have paid?
Compensation, they have to go before the EC Act, my lord.
But have you paid it?
No, that I will take care. My
No,
lord.
what happened in this case, my lord? Notice issued, my lord. OP3, my lord. The notice answer, my lord, is not, AD not return or answer notice not return.
No, party coach.
Notice.
Notice
Awaiting notice.
Urgent.
Item delivered.
Delivered, na?
Delivered. Item delivered.
So then next week, in the place of notice was issued to the opposite parties, number 2. You are not. Where is the victim?
Victim, 3.
You have not implemented victim.
Yes, my lord. Amendment 5. Yes, my lord.
Opposite party 3.
Yes, my lord. Case file করছো আউ দুটা কেসে ফাইলিং
You first.
এইটারে ফাইলিং
দেখো তো opposite party 3 implemented.
Last my lord, order, no order has passed, my lord.
Not implemented any.
First matter is opposite.
They have filed the IA, my lord.
3.
First matter.
And the other 2 matters, the IA is allowed. The victim of the case is implicated as opposite party number 3. Issue notice to opposite party number.
এইটারে করছো
It is the tag. Koda matter baki.
First matter H.
What about the other 2 matters?
Other 2 matters both.
Which one? Listed.
By mistake he has skipped, but there that is in the file.
Listed. Okay. Other 2 matters the application allow karo. Opposite party number 3 to notice.
Implement
List sir.
implement kariyo.
আরদিটা ম্যাটারে ডাইরেকশন হেই নথিলা এই ম্যাটারে ডাইরেকশন হেইতলা এটা প্রশ্ন
Anyway, now I am giving that direction. ठीक है? Okay. Returnable karo.
interim order
Interim order. Yes. Next 5.
Item 5.
May it please, your lordship.
Yes.
In this item, your lordship, previously your lordship directed the learned counsel for the state to issue notice to the victim through the police station, whether the state will clarify, my lord, whether they serve the notice through the police.
But there is available, man.
We have the service on respondent of 5.
Asini seda asini. IS through pathai dilu kintu but there is available here, man.
Mr. Agada submit that neither the case diary has case diary received by him nor the service report on the opposite party number 5. Leave the matter on such. Yes.
Item 6.
Yes. What is this matter?
6.
Entire CS case number.
But the case belongs to, my lord, the accused person. Case, my lord, happens to taken place at Calcutta, my lord. They have filed the case here, my lord. With a prayer.
Notice was issued?
No, my lord.
Such matter.
Yesterday matter list could not reach man for that.
Okay.
In fact, my lord, the pray, my lord, they allow the petition quash and set aside the entire proceeding. My lord, institution how can my lord the judicial?
Pass over correct.
Yes, ma'am. Item 7.
What is this matter?
Compromise matter, my lord. Two cases, my lord.
Settled.
Yes, ma'am.
Fresh matter, but they are aberment made their petition, but their matter has been settled.
Pass over.
Item 8.
There are defects, my lord, but copy not sought.
Here. None appears. The registry pointed out certain defects which has not been cured. Adjourned to. Yes.
Item 9.
May it please your lordship. Lordship, it is showing that
Yes.
I am the 7 items that are pass over, my lord. Compromise, two compromise matters.
Where are they?
Party yes.
Yes, after location.
Adjourned to. Yes.
Lordship.
9.
Item 9.
Lordship. Lordship, here the petitioner is the director of Premier Nursing Institute of Odisha,
Yes.
which is situated at Jharsuguda.
Hmm.
And the daughter of the informant, who was a student at that institute. She belongs to scheduled caste, scheduled tribe category. And unfortunately, on that day, there was some certain disturbance between three girls. That means the daughter of the informant and another 2 girls, so they have been implicated as the accused in this present case. But out of being vindictive, the mother of that girl lodged FIR against me on 1/2/2021.
What are the allegations?
Allegation, lordship. Lordship, may I be allowed to read the FIR, lordship?
I'm already reading it. ಈ ವಿಷୟରେ ମୋର ଝିଅ ମୋତେ ସକାଳେ ଆମର କହିଲା ଡାଇରେକ୍ଟରଙ୍କୁ ଆମ ସ୍ଥିତି ନନ୍ଦ ତାଙ୍କ ଘଟଣା ବିଷୟରେ ଜାଣିବାକୁ ପାଇଛି ସେ ମୋର କଥାକୁ କିଣିବାକୁ ରାଜି ନାହିଁ ମୋତେ କହିଲେ ଯେ କଲେଜକୁ ଆସି ଦେଖା କରୁଛୁ Yes, yes, Mr. Gowda.
Madam.
Only he refused to meet.
The first time elected, I have to update the
Issue notice.
Lordship, may I be allowed the
IA for what?
for stay of the trial?
Trial is at what stage?
Trial has not been started.
Not been commenced.
Not yet commenced.
What is the answer?
Notice of OP2.
OP2. Yes.
Item 10.
Deep loop.
Yes.
This case notice has become sufficient.
Yes.
Sufficient notice issued to the opposite party number 2, that has been sufficient.
Yes.
Both the petitioner and the opposite party number 2 has filed a compromise petition before the learned court below.
Why he is not appearing?
Well,
Why he is not appearing?
he is now at Canada. Both petitioner and opposite party number 2 are working in the IT sector.
Canada.
Yes, my lord.
Where is your client?
My client is at Bhubaneswar.
Milords, I am appearing for opposite part number 2. On the
Yes.
last occasion, she was there. Milords, I am praying for a Passover. My client can join virtually.
Okay,
And if
pass out. Yes.
Passover at 2 p.m., my client can join virtually.
2 p.m. Okay.
My lord.
Much.
Item 11.
May I please, Your Lord?
Here, my lord, passing over the proceeding on the ground of the compromise, my lords.
Where are
The,
they?
pardon, my lord.
Where are the other people?
So far, my lord, the informant is concerned, my lord, I made party as opposite part number 2, my lord.
Notice my lord.
Which notice?
My lordship, I am appearing for the informant OP2. My lordship, now the dispute between us has been settled amicably. And
Let them come.
in that light, I am giving an affidavit, my lordship.
But where? They have to come here.
Yes, they are present,
yes,
my
ma'am.
lordship. Informant is present.
Informative. What about the accused?
So for the accused, 12 petitioners are there, my lordship, my lords. So if your lordship will permit, my lords, I will appear them through VC, my lord. 12 persons has to come here, my lords.
What is the figure? They are accused. They are not
They date may fix on that day.
fixed next week.
Any date may fix, my lord. So that, my lord, I will intimate them to come on that day, my lord.
Next week.
Date at
My lordship,
DWL.
Yes.
Item 12.
My lord, I am in VC, your lordship may allow in VC mode.
Yes.
Oblige.
My lord, initially an FIR was registered against me. I am a labor contractor. I take people, I am a labor contractor having license of taking 100 people. Your lordship had heard this matter extensively. I have, the allegation is 373, 417, 120B and 25 of the Interstate Migrant Workmen's Act 1979. Charge sheet has also been filed. I have put the charge sheet, it is on the record, my lord. Your lordship may also see that is there in the list that entire charge sheet has been filed. The entire charge sheet shows that people had boarded the train from Kontabanji and they were found where they stated that we are being taken to Andhra Pradesh to work in the brink links. This is the entire allegation. There is no case of cheating or anything against me. Your lordship will see the entire statement of all the workers who have been whose statement was recorded under one.
Are you ready?
Yes, my lord.
Yes.
My lord, there is no valid license for sending the supply the labor, my lord, towards the outside. And this petitioner is a main accused, my lord, who has brought the labors illegally and transporting to the other states. My lord.
Kindly see the
And
statement.
regarding that, my lord, the already charge sheet has been filed, my lord, and the 161 statements of different labors, they have made the statement against this petitioner, my lord. And also, my lord, I would like to only read only 3 line, my lord. For this, I have prayed for Hon'Ble Court that imbue also has been issued against this petitioner, my lord. And there is no valid license issued under the Interstate Migrant Workmen of this petitioner, my lord. And
Kindly see the statements, my lord. Let them place the statements. Your lordship can find out the truth.
Yes.
my lord, that is the complainant and one of a labor, my lord. If your lordship allow to me, I may be ready, my lord. My lord.
Yes.
My lord, Mon Namo Bhisma Majhi, my lord, a labor, my lord. So and so. on
Where
the-
are you reading?
My lord, CD from the charge sheet, my
Okay.
my lord, बयान एक ही जे ता 1/11 इरख दिन आश्रम पड़ार स्वयंसो तैयारी कले पप्पू अब्दुल साजिद खान दिस पिटिशनर पप्पू अलियास कापू खान मो पाखु आसी हैदराबाद रे इटा तैयारी कले अधिका पैसा मिलिबो कहि हमकु ठकी अधिका पैसा रोजगार लालसा देखाई निज फायदा पई षडयंत्र करी किछि पैसा देई गंतव्य स्थल रे पहुंचिले अधिका पैसा देबु बोली कहि कंटामजी रेलवे स्टेशन रु पुरी शिरडी साई एक्सप्रेस रे जिबा पई कहिला मु ता कथा रे लोभरे पड़ी सकाळू कंटाबांजी स्टेशन को आसिली उक्त लेबर सरदार आम ग्राम रे उक्त लेबर सरदार आई मीन दिस पिटिशनर सरदार आम ग्राम रे आन्ने माझी अशोक जानी तुनी माझी सिन्हा जानी कुंजर भोई करणीय भोई कुबेर माझी विकास भोई जोगेश्वर जानी एंड सो अदर्स हैदराबाद को इटा तैयारी काम करबा पई कंटाबांजी रेलवे स्टेशन को डाकिथिला
ସେଥିପାଇଁ ସେମାନେ ତାଙ୍କ ପିଲା ଛୁଆମାନଙ୍କୁ ଧରି ଆସିଥିଲେ। ସେଟାରେ ଆହୁରି ମୋ ପରି ଅନ୍ୟ ଗ୍ରାମର ଲୋକମାନେ ମଧ୍ୟ ଉପସ୍ଥିତ ଥିଲେ। ମୁଁ ସେମାନଙ୍କୁ ପଚାରିବା ଜାଣିଲି ଯେ ସେମାନଙ୍କୁ ମଧ୍ୟ ଲେବର ସର୍ଦ୍ଦାର ଅବଦୁଲ ସାଜିଦ ଖାନ, ପପୁ, କାପୁ ଖାନ କିଛି ପଇସା ଲୋଭ ଦେଖାଇ ଇଟା ତିଆରି କରିବା ପାଇଁ ହାଇଦ୍ରାବାଦକୁ ପୁରୀ ଶିରିଡି ସାଇ ଏକ୍ସପ୍ରେସରେ ପଠାଉଛି। ଯେହେତୁ ଆମେ ଲେବର ଲୋକ, ତେଣୁ ଲେବର ସର୍ଦ୍ଦାର ମାନେ ଆମମାନଙ୍କୁ ଠକେଇ ଟଙ୍କାର ପ୍ରଲୋଭନ ଦେଖାଇ ଅନ୍ୟ ରାଜ୍ୟକୁ ପଠାଇଥାନ୍ତି, କିନ୍ତୁ କୌଣସି କାଗଜପତ୍ର ଆମ ନାମରେ ତିଆରି କରିନାହାନ୍ତି, ଆମକୁ କୌଣସି ସରକାରୀ କାଗଜପତ୍ର ଦେଇନାହାନ୍ତି। ସେମାନେ ଏହିପରି ଭାବରେ ଆମ ନିରୀହ ଲୋକମାନଙ୍କୁ ଟଙ୍କାର ପ୍ରଲୋଭନ
This
ଦେଖାଇ
is one evidence
My lord.
and any other evidence?
My lord. My lord, there is a report from that there is no valid license, my lord.
That's right.
Another one is, my lord.
How many witnesses have said?
There are, my lord,
They have recorded number of witness. Everybody
number of
have stated.
witnesses, my lord.
Everybody, my lord, everybody have stated that we were given some money.
First of all,
we were asked to
my lord,
board
there
the
is no
plane.
valid license for import and export the labor.
Certificate. My lord, entire statements was placed by me last occasion. All the statements say that we were paid some money. We were asked to board the train. We boarded the train, and after reaching money, rest money will be paid after the work. So, my lord, there is no case of cheating. And my lord, the 100 license, valid license I had placed on the record last occasion, which is there available on the record. I can take 100%. My lord, here what has happened, the entire allegation is that I have been involved in trafficking. My lord, where is the question of trafficking?
You have to prove your license in the trial, not that
yes, obviously.
Validity of the license, whether you have taken them rightly or wrongly, all these things should be tested in the right day.
Absolutely, my lord. Your lordship will not test in 482. I am aware, my lord. But question is, my lord.
I am giving that liberty. You won't argue about it.
My lord, I will place all my records before the police authorities. Your lordship may protect me so that I can place my records.
Investigation is still on.
No, charge sheet has been filed.
My lord.
What the police will do?
The important thing is, my lord, there is AVLPL number 9568/2023 not complied because there was the order for surrender, my lord. And another one, AVLPL 12498, my lord, that has been rejected, my lord. And
My
since
lord, I have
from
annexed
that this
the
petition
document.
is absconder, my lord.
What?
I have annexed the document. I have not hidden anything.
No, he is not saying that. But in the face of these two orders, what protection could be given? Yes.
My lord, your lordship may protect me so that I can place my records.
I pass any protection order, that means I am nullifying the two orders passed by the coordinate bench.
No, my lord, your lordship may kindly turn to page 34 for a moment.
Yes.
Kindly see 34.
Yes.
I was asked to surrender within 21 working days and move for bail. My lord, your lordship may allow me some interim protection so that I can appear before
I will allow in view of the order of the coordinate bench, I will extend the time.
And allow me to place all my records in the trial at the time of framing of charge.
Then counsel the petitioner seeks to withdraw this petition to.
My lord may not say withdraw, my lord. Withdraw will put me in difficulty. Your lordship may pass on merits. Your lordship knows withdraw means again I have nowadays your lordship knows the clients how they.
Okay. Give it to me. I'll pass you. Yes. Okay. Pass you. Okay. Next.
Madam 13.
Your lordship is reserving.
Not reserving. Today only I'll pass.
My lord, I only pray your lordship may protect me for some time so that I can place the matters before the court.
Yes. Yes.
Item 13 and 14 on behalf of Mr. Das. Let him start copy of the IA limitation petition.
Yes, I. Lordship, in this case, lordship, can I spare one thing, lordship?
How many days delay?
Delay is lordship.
I pass it over both the matters.
Lordship, delay. Lordship, for SR must have been pointed. No, SR must have been pointed. Lordship.
Yes, your lordship knows.
Delay.
Can I say
You might have moved the application. You
Yes,
must have moved it.
I have moved lordship.
The copy of that application has not been given. Let him serve the
Delay,
copy.
small delay. Let us.
Because
Small ହେଲେ ଦିନେ ସେଟା ଠିକ ଅଛି କିନ୍ତୁ
କେତେ delay କଣ?
small delay ମାସେ ଭିତରେ
ମାସେ ଭିତରେ
40 days 40
40 days.
40 days lordship.
Come on, merit.
Lordship.
merit ହେଲେ ସେଠି Mr. Das
Let me, nothing to be decided. All
because he's in
lordship, nothing to be decided.
Deciding.
Lordship, can we see that? Last time only one judgment of, we have, lordship, can see judgment of apex court. That the principal accused, whose account has been freezed, that all account.
This is a revision against the conviction.
Conviction. No, against lordship, because I had, lordship, my account has been freezed by the opposite party's lordship. On the report of the vigilance, my account has been freezed.
Yes.
And subsequently, I had filed a 457 petition before the land court below. That has been rejected. Against that order, I have come on revision, lordship. And here, lordship, the petitioner is in no way connected. So far, the case is concerned. So DA against this Tinath Mishra, lordship.
Who are you?
Lordship, they are saying, lordship, my relation was working under that person before some years, lordship. That's why that account is Benami. Lordship, they're saying Benami. And lordship, and that petition, lordship, can see they have come up with applicable to 102 of the CRPC. Lordship, kindly see the
I'll issue notice.
lordship, more lordship, kindly see the order. No, kichi nahi. Kahinki je principal accused,
I have to the other side.
investigation is to be seen.
I'm keeping it.
No, mo se tikke koi do lordship, because perhaps I'm not properly communicated, lordship. Lordship, here the principal accused is one Tinath Mishra, lordship. While working as a police officer, a DA was conducted by the Vigilance Department, lordship.
Have they initiated special court act proceeding?
No, I don't have that instruction. I don't have the file at all.
I'll tell you.
It's a DA case.
So it is to be seen.
Lordship, it is under the PC Act, lordship, Prevention Corruption Act.
Tinath, what is
Tinath Mishra, lordship.
Tinath Mishra.
Tinath Mishra.
Yes.
Lordship. But during investigation, lordship, can you look at the order of the
Yes, tell me, I understand.
lordship, during investigation, lordship, they connected me, lordship, with a lordship presumption that one of my relation was working under him few years back, lordship, while he was IIC in the Salehpur police station.
Yes.
And because I am relation of his cook, lordship, my accounts has been seized by the Vigilance Department.
Benami things are always done through your near dear only.
That is a presumption, lordship. There is no connection. But lordship, can look at the order of the Hon'Ble Apex Court.
What does it say?
Apex, lordship, can see. Lordship, here the here, lordship, kindly see, below they have made entire exercise in researching 102 of the CRPC, lordship. While initiating proceeding under a special statute, lordship, they have, lordship, freezed my account. And they taken over my account, lordship.
You say that they have resorted to a wrong procedure.
Wrong procedure. That's why, lordship, Supreme Court has given Supreme Court. And lordship, keeping in view this,
I am conscious of.
they have defreezed, lordship, all the accounts of the principal accused.
That's right, because they have an option under the Special Courts Act also.
Lord, but lordship, they have not registered. They have justified.
They have invoked 102.
102, lordship.
You say Supreme Court says that you can't.
18A
You can't employ 102 to
Great. Grateful, lordship.
So far as 18A is concerned, 102 that is not bar so far as seizure is concerned and investigation is concerned. During course of investigation, we can seize it. So far as 18A is concerned, that is related to attachment and confiscation.
Right.
It is to be seen whether we are attaching it for the
That's
purpose
what I
of
want to know.
confiscation.
That's what
So
I want to know.
that's
Seizure
requires,
is no problem.
my lord.
When it comes to confiscation, you follow
That procedure to be followed.
whether you have followed those procedures or not.
But it is to be seen whether we are proceeding on confiscation or not.
Copy to me.
Yes, I got.
I am conscious of that judgment.
And lordship, that has been tested and all the accounts of the principal accused defreezed, lordship. More again,
We'll defreeze what
lordship.
if they have not followed the procedure.
Lordship, that.
For the purpose of confiscation.
More, lordship, another aspect, lordship, lordship, see the period, lordship. 2023 through more account rejected. Now it is 2024. In the meantime, lordship, they have not proved the nexus also, lordship. And nothing is there.
Nexus
A principal question is a
Next week,
next week, lordship. Next. Both the cases.
Yes.
15.
Next Friday.
Lordship, delayed a case admission.
Delay condone, issue notice to opposite party.
Lordship.
Yes.
ଦେଇଥିଲେ ଆଉ ଗୋଟେ,
Item 50.
What was the order? The petitioners were granted time to surrender before court on or before 29/2/2024. Six extension of the time through this application. The application is allowed. Time is extended to 30th May. 30th May. Yes.
Item 16.
Lordship, may I please, Lordship? Lordship, application for extension of time, Lordship, modification of order, Lordship.
Extension of
Petitioner
time.
to surrender before the court 10th April 2024, Lordship.
On or before କେତେ ଥିଲା? On or before ଥିଲା 10/4/2024. May କରିଦିଅ. ଠିକ allowed.
Item 17.
May I please, Lordship? Both were right. It is made clear that no further extension.
May I please, Your Lordship?
No further extension shall be given.
May I please,
Yes.
Your Lordship? Due to some typographical mistake, it has been mentioned in the order sheet, my lord.
Yes.
Due to some typographical mistake, it has been mentioned in the order sheet. The GR case number 148 of 2023 instead of 184 of
GR
2023.
case number 36. No, sorry. GR case number 148.
Again.
କେତେ ହବା କଥା?
It have 184.
84 ହବା କଥା. ଆପଣ ଦେଖିଛନ୍ତି କଣ? ଦେଖିବ. Whose mistake is this? अच्छा 184 होगा तो देखो देखिए करेक्टली 148 लिखी हैं
It may be verified with the principal first.
नहीं
petition.
in the main petition he has written
Yes.
GR case number 184
In the
48 is it.
in our petition, we have written correctly.
Correct. GR
Right.
case correct करो. Order
Right.
dated 14/3/24 order में GR correct. ठीक. Allowed.
Item 18.
Extension.
Extension of time, madam.
Yes. Extension of time. How many extension you have taken?
No, my difficulty is there. Man, the last occasion you wrote directed to surrender, but the time extension was not taken into consideration. For that reason, it is difficult. Immediately, I got the certified copy, but the next date it is difficult. That's why I asked minister.
This petitioner is granted time up till 28/9/2022 to surrender. The six extension of time. May 30th May.
13 May.
30th 30 May. No
Much
further
obliged, much
extension.
obliged.
No further extension.
No, yeah, much obliged to that extent.
Item 20.
Let's the judgment basing upon which I have prayed for passment of the confiscation case, that matter is sub judice before the Honorable Apex Court. So,
in view of the fact that the connected matter is sub judice before the Supreme Court, that's it.
interim order to continue matters.
Interim order to continue.
Obliged.
21.
21, may I please, my lords? 21, may I please, my lords?
Yes.
My lords, on last occasion, your lordship has asked me to furnish the judgment as relied by the learned JMFC Santala for taking the cognizance order. I'll place that judgment first, my lord. I have challenged the cognizance order, my lord, in this case.
Yes.
Which is at running page number 65, annexure 3, my lord.
65. Yes, Mr. Maharaj, are ready?
Yes, sir. Just now, they served me the decisions.
That is there in the, my lord, cognizance order.
From that decision also, I have, just now I have some to extent.
I'll just take it up. Just. I'll just take it up.
My
Just
lord.
read it.
My lord, my lord. Despite having the fact that once 97 acts as a bar for taking cognizance without a valid sanction against the publisher.
It's not cited. Yes, yes.
Yes, my lord. That is
State of
cited.
Himachal Pradesh.
So, my lord, to that effect, your lordship has asked me to refer that judgment. My lord, the relevant portion of that, I have supplied the judgment copy also.
Yes.
The relevant portion of that judgment is paragraph 10, my lord.
Yes.
My lord, may I read from section 197 itself, my lord? What the statute says?
Come to the point.
The section, last paragraph, my lord.
Falls in the chapter.
The section falls into the chapter dealing with condition requisite for initiation of proceeding. That is, if the condition mentioned are not made out or are absent, no prosecution can be set in motion. For instance, no prosecution can be initiated in a court of session under section 193, as it cannot take cognizance as a court of original jurisdiction of any offense unless the case has been committed by magistrate or the code expressly provides for it, and the jurisdiction of a magistrate to take cognizance of any offense is provided by section 190 of the code, either on receipt of complaint or upon police report or upon information received from paragraph 10 from the first statement. I am referring. Upon his knowledge that such offense has been committed, so far as public servants.
What is your point?
My lord, this judgment is not applicable for me because this deals with the PC Act, my lord. And this involves an offense in which the public servant was charged for corruption, my lord. That is mentioned, if my lord comes to.
No, the trial court might have wrongly relied upon the judgment, but
Yes,
what
my
is
lord.
the fact? It is a
My lord,
cognizance order.
in this case,
In a cognizance order, you just tell me what are the allegations against you and
my lord, so far as the present case is concerned, my lord, the sole allegation that I have issued caste certificate, which is, my lord, in dispute. That is the sole.
you are the Tahsildar.
I was the Tahsildar during the time of issuance of certificate, my lord. But the for verification of the certificate, my lord knows that revenue inspector has to do the ground.
On the way, what your case is, the revenue inspector gave a report on that basis. You issued the certificate.
My lord, that is my case.
Why are you going here?
That
here
is my
and there?
case. To
That's the
that
whole
effect.
case.
To that effect.
So therefore, no case is made out against you.
No
That's
case
what-
is made out. My
What do you say?
My lord. Number one, my lord, this is a case of the year 2012.
You're right.
Now, the cognizance has been taken in the year 2002, 5, 2015.
What is the stage now?
He is absconding since then.
Okay.
He is absconding since then, and he is not.
What kind of Tahsildar you are absconding?
My lord, specifically, I have averred that in my paragraph E that in the year 2008, I was the Tahsildar Titlagarh. 2008 to 12, I was district project coordinator Kalahandi. 2013 to 16, I was sub collector Malkangiri. 16 to 18, joint secretary Panchayat Raj department. 18 to 20, my lord.
Okay.
Till now, my lord, I am working as a government servant, my lord.
Not relevant to this. Yes, we can appeal.
My lord,
No paper is shown.
Anyway, that's not the cognizance order.
This case is under section 420, 467, 468, 471, 477A, 120B IPC. So he cannot be exonerated 120B, even if accepting the total entire allegations.
Go and argue before this.
My lord, to that effect, my lord, this.
In cognizance stage, why should I go into
My lord, to
spirit
that
stage?
effect,
Since he was police was wrong to say that he was absconding.
my lord, without
Because
a
he is working in your own government. So what best could be done is, since the absconding part is wrong, I'll protect him, let him go. And
no, my lord, the entire cognizance has to go, my lord. My lord, may I have a glance to the judgment which I have relied, my lord.
Yes.
My lord, may I draw my lord's attention to starting from paragraph 31.
Absence of sanction.
Absence of sanction, my lord. To that effect, if my lord.
How do you address that issue, Mr. Maharaj?
Yes, I'm
May I place, my lord?
Yes, I know this.
And my lord, to that effect, another judgment which has been passed by the
What
court.
he says is the capacity of the Tahsildar. He has issued the certificate. Fake certificate, maybe fake certificate, and that too on the basis of the feedback given by his junior officers.
Yes, my lord.
So therefore, in the official capacity, he has done it.
Yes.
Madam.
Therefore, why before taking cognizance, 197 should have been complied. This is his whole.
And
What is your answer to that?
And another judgment of the court judgment of the
On facts, I am arguing for you.
Oh, bless.
Unnecessary, you are taking me here, there.
The entire case.
Because there is a bar to take cognizance.
Exactly.
Yes.
I am coming to that, well.
Yes.
In this case has not only registered under section 460 or 420 or 471 only. It's a case including 120B.
Maybe he's
So
correct.
can it be exonerated that?
No.
Cannot
All the case is made out. No problem.
Yes.
Without sanction, can you proceed?
Yes.
You show me how satisfied.
That I am drawing yours. Your lordship is holding, my friend has given the decision that is 2004 to Supreme
You
Court.
can't say that in his personal capacity he issued the certificate. It is during the color of duty. It comes under the color of duty.
Color of duty.
So therefore, the sanction, according to him, should have been taken before the cognizance is taken. There is a clear path.
That with connivance with the RI.
I am not on merit.
Yes.
On merit. Are you suggesting that the act complaint
of
the act complaint of is not falling under the color of duty?
No. Yes. It is not coming under the color of duty. What he has done with connivance of the principal accused, and 120B is there. This is not on part of his duty. So my decision, my lord, this decision has been.
Is there any allegation that he has taken money?
The money part is not
My
there.
lord, there is
Money
nothing
part
to
is
show,
not
my
there.
lord.
But it cannot be. It's not so easy to establish. It's a case of 2012. That point of time, the evidence has been taken, the statement has been taken that with the connivance of the RI, these entire things have happened. Because the person who was taken cash certificate is not the actually civil.
Show me the allegation.
Yes.
Can you take it out of color of duty? Yes.
Investigation, Madam Charsit, I am just reading some point.
Charge sheet?
Charge sheet, page 10.
Yes.
Investigation of the case disclosed that, second part.
Page 10.
Page 10.
Okay.
Third.
No, page 10.
Third, investigation of the case.
1 minute.
Running page number 17.
No, running page number 17.
এটা তো
Charge sheet.
charge sheet.
Charge sheet, that is page 32. Page 32.
3-2. Okay.
32 of the brief.
Yes.
Third para investigation of the case disclosed.
Yes.
What starts? That one Govinda Pradhan.
Yes, I am.
One Govinda Pradhan of village Pandali Chaudhary, district Sundarpur, had only daughter, namely Pratibha Pradhan, alias Kuni. Kuni is the person who has got the caste certificate. Kuni Malik. During her childhood, her father and his friend, namely Sibo Malik, Kondha by caste, ST of same village, Pahadandi, conspired together to adopt Kuni Pradhan by Sibo Malik, only obtain and enjoy all kinds of privilege help from government of Orissa. As a member of ST and at the instance of Sri Sebak Malik, Pratibha Pradhan alias Kuni Malik was adopted by Sebak Malik orally.
Sebak Malik adopted the Kuni Malik. Sebak Malik is ST.
Okay. No document was prepared for such adoption nor any agreement was made to that effect. In the process, Kuni Malik became the daughter of a Sebak Malik and started posing herself to be the daughter of a Sebak Malik by birth. They got her admitted in the village primary school as Pratibha alias Kuni Malik, daughter of Sebak Malik, caste Kondha, ST, and continued her studies. On 2/5/2007, she obtained ST caste certificate by caste certificate number so and so from the Tahsil office Sonpur. Accordingly, Tahsildar Sonpur issued caste certificate by caste certificate number so and so. Based upon which she managed to get the job of a cook of assistant attendant in ST Development Department School and was working as such in Kashyarama Santi Lata. The accused Kuni Malik alias Pratibha actually belonged to Dumal by caste, which comes under SC/BC caste by birth. But in order to take the benefit of admission to the ST caste people, she was soon adopted by Sebak Malik of the same village by her father Govind Pradhan in her childhood. Hence, the caste certificate obtained by her was a fake one. And on the strength of that certificate, could manage to get a job in SC/ST Development Department School. And
What have you done to verify whether the
Yes,
the adoption is valid or not? It may be a customary adoption also.
No, that is
What have you?
That is the
Because everything rests upon that adoption. If the adoption
that
is
is no
valid,
agreement, no adoption deed, nothing else. That is why
in the customary adoption, it is not required.
see,
That the homo is required.
it is the investigation orally adopted. Orally adopted. There is no paper. No
See,
document.
in the customary adoption, no documentation is required. Only a datto homum has to be carried out.
Certainly not.
What is the investigation you have carried out?
Yes, this
Show me.
orally କେବଳ ହେଇଛି ଯାହାକୁ ପଚାରିଲେ ନା ସେ ତାଙ୍କର ପୋଷକ ଭାବରେ ସେ ତାଙ୍କର ରଖିଥିଲେ. That is the only oral.
Where is that?
That is nothing. That is I have taken Milan. I have read out that portion. The because the daughter. Yes, here. Malab the as a member of ST at the instance of Sebak Malik, Pratibha Pradhan alias Punni Malik was adopted by Sebak Malik orally. That is the investigation. There is no such evidence given by the local people. So now,
Last paragraph you read.
what again?
Last line. That apart, the concerned additional Tahsildar, Dongurpally, and Tahsildar, Titlagar, ex-RI of so-and-so,
yes,
who had issued the caste certificate in favor of the lady Kuni so-and-so,
yes,
without proper application of mind
Yes, sir.
and improper verification. Inquiry into. Son, these are coming under the colors of your duty. How can
Yes,
you
madam.
take it out? It is non-application of mind. A order is passed, wrong, right, whatever. It is maybe a judgmental error. It may be a dereliction of duty. So how will you take it out from
that's why the decision has stated that.
Show me this.
Yes, the 2004, two Supreme Court cases 349.
That is there, my lord. The first judgment.
Yes, given.
State of Himachal Pradesh, my lord.
Yes.
From his decision, I am placing.
That is the decision by
That
the.
apart, my lord, the para 21. That apart, the contention of the respondent that for offence under section 406, 409, due to section 120B IPC, sanction under section 187 code is a condition precedent for launching the prosecution is equally fallacious. This court has stated the legal position in Srikant Ramayana Munipalla case and also Amit Singh case that it is not every offence committed by a public servant which requires sanction for prosecution under section 197 of the code, nor even every act done by him while he is actually engaged in the performance of his official duties. Following the above legal position, it was held in Harihar Prasad versus State of Bihar as follows. As far as the offence of criminal conspiracy, punishable under section 120B, due to section 409 of Indian Penal Code is concerned, and also section 5, subsection 2 of the Prevention of Corruption Act are concerned, they cannot be said to be of the nature mentioned in section 197 of the Code of Criminal Procedure. To put it shortly, it is no part of the duty of a public servant while discharging the official duty to enter into a criminal conspiracy, and my case is 120B, or to indulge in criminal misconduct. Want of sanction under section 197 of the Code of Criminal Procedure is therefore no bar. Then, my lord, para 22. Above views are reiterated in state of Kerala versus B. Pondalama.
It only says that if 120B is there,
Yes, my lord.
sanction is not required.
Not
Basically, it is.
My lord. May some.
Forgery, value and security, and forgery for the purpose of cheating and using genuine for
21 also said. The para 22 also said.
22, my lord, talks about forgery, related to forgery. Yes. My lord, in this, that is not applicable to the present case.
Forgery for the purpose of cheating and using a genuine false document respectively, it is no part of the duty of a public servant while discharging the official duty to commit forgery of the type covered by the aforesaid offences. Want of sanction is not barred.
My lord, there is absolutely no material to show as a prima facie that 120B can never be attracted to me. My lord,
My lord,
there is negligence of my. There is
also. My lord Justice, my lord
R.K.
R.K. Patnaik. He has given all the decision. I am from that. I am just now very glad.
Where are those?
My lord, I am giving. My lord. No, Dej. Huh. Para 7.
That has also been taken care of. My lord, your para 70 also.
You are relying upon the judgment given by him only. Huh?
ସେଟା ମୁଁ ଦେଖିଛି ତ ମୋର 120 B ଟା ମୁଁ କହୁଛି ମୋର 120 B ଅଛି so let him to exonerate himself from 120 B.
What about the other offences?
Other offences will let him go. 120 B
My lord,
how can be exonerated?
my lord, to the effect of 120 B.
My please.
My lord, 120 B has to be prima facie made out, my lord.
Conspiracy for what?
Conspiracy for what? My lord, where is that? Investigation doesn't reveal that, my lord.
Not we are the party of the case. Only you can presume or assume, not subtracting anything, not adding anything. Whatever there in the evidence, that is to be accepted.
Judgment reserve.
My lord, just 2 lines may I place, my lord, from this judgment. Your lordship has already relayed just to the effect of.
Which judgment you are talking
My
about?
lord, Devraj judgment.
Devraj, yes.
T. Devraj.
Yes. Which para?
My lord, D. Devraj 77, my lord. Although
75.
my lord, starting from 72.
Yes.
The language, if
Yes.
the language and tenor of section 197 of Code of Criminal Procedure and section 170 of Karnataka Police Act makes it absolutely clear that sanction is required not only to act, not only for acts done in discharge of duty, it also
Next paragraph.
next paragraph, my lord.
Which one?
To decide whether sanction is necessary, the test is whether the act is totally unconnected with the official duty, my lord, my case, my lord, or whether there is a reasonable connection with the official duty.
Yes.
My lord. And my lord, another point.
My last submission.
My lord, last one is.
If you have any independent judgment of your own, you give it.
This is the recent judgment.
If at all he is innocent, this is a case of the year 2012. Cognizance taken in the year 2015. After, my lord, 15 years, 16 years, where he was, he has not challenged. That itself presumed that he has something. Right? He did
My lord,
something.
specifically, I have averred that in my petition, my lord. I was unaware about such a case has been instituted as against me.
What your IO was doing? He was
I was
a
a
government officer posted in this place, that place. How can you?
Exactly, my lord. John is trying to absent our bank. ତାକୁ କୋଉ IO ବି arrest କରିପାରିବେନି.
My lord, I was discharging my official duty, my lord.
Anyway, I'll take care of it.
And my lord, to the effect, last 80 number paragraph has categorically stated that after having held that it was recognized.
After convincing me so much, you want to dissuade me from counseling.
Highly obliged, my lord. Highly obliged.
Yes. 22. Yes.
Your lordship, the three connected matters is there, lordship. Last occasion in CRLMC number 416/2023, your lordship.
This is your.
And director for taking instruction regarding if there is any chance for compromise, your lordship. So all 3 matter may be taken up next week.
Is there any chance?
Yes, there is chance.
What are the allegations, by the way?
Matter arises out of civil dispute, your lordship. Your lordship, last of I am
The petition is here in challenge. No, you are appealing for.
Yeah, I am for the petition.
Shall I send you to mediation? Work it out and tell.
Yes, madam. But the 3 matters,
three matters
are
there
pending.
All the 3 matters I am sending.
Yes, madam. I have furnished the list on the last occasion.
You work it out.
Yes.
If anything happens, it happens.
Yes.
Otherwise. Right now. So it is for petition, for open part. Jointly, the councils appearing for the party submits that there is a possibility of settlement in the matter. All the 3 matters. Give the number, huh? All the 3.
4087 up to
whatever you give.
2023, that has been adjourned to 27th of July by your lords. One of the item has been adjourned to 24th of July.
The present matter is connected with the number.
I am fine.
The council for the parties submits that the dispute is arising out of a commercial transaction.
No, this is a
Property.
civil dispute,
Okay.
property
It
relating.
is primarily a civil in nature, and there is all possibility of settlement. All possibility of settlement. Therefore, on the joint request, the matter is relegated to the High Court mediation cell, and the coordinator is directed to issue notice to the parties to fixing a date for the purpose of mediation, awaiting the mediation report, reach the matter. All three matters.
Other two matters, interim order is there, but
Interim order to continue.
in this matter, no interim order has passed. Let the IA be allowed.
Interim order, I have interim order. Further proceeding is also. Okay. 23, all the three matters, you go and explore the possibilities.
Yes.
My lord, item 23, I am oppositing.
Pass over, Lordship.
Milord.
And the interim order of the other side has taken action.
Interim order will be extended.
From the beginning, without informing me, he has taken action.
My lord, this item 23.
Your friend, I
only think that
interim order will continue wherever there, unless wherever interim orders are there, they will yes. Yeah, 23
Item
years.
23. So it was had only in the month of March, and thereafter continuously they are taking adjournment. So,
Pass over only.
Passover means after lunch first matter, then not.
Pass.
Passover.
Passover
you are opposing. Passover.
Yes. 24, item 24, that the matter leads to that in extra the Lord JMC Kantavan is not taking step for conclusion of the 130 10 Act matters. The Lordship was pleased to issue notice, and pursuant to the notice, the other side has appeared. And I have served him copy of the
My lord, petitioner has not copy, sir.
Petition?
Has not copy, sir.
Sir, notice जाइथिला. Pursuant to notice they appeared. One last.
Okay, you give a notice.
Yes.
Next week. What is your grievance?
More 130 10 Act, 148 2 episodes.
You are the complainant.
Yes,
You are the
since 2022. In course of day, I'm submitting one more copy. Lordship, keep it next week. That is
Yeah, next.
Lordship, on the plea of.
I'll only expedite because see, in 138
Yes,
matters, the law says 6 months.
Yes.
It is expected that it should be over by
22 complaint.
What do you say? She's not sure. You give a copy.
Next week, ଶୀଘ୍ର ସାରିବା ପାଇଁ କୋଉ ଡାଇରେକ୍ସନ ଦେବେ ତାପରେ କଣ ଆପଣଙ୍କର ଅବଜେକ୍ସନ ଅଛି
My lord, unable to trace out the copy at the chamber, so.
One more copy I'm giving. Yes, let's keep it next weekend.
Yes, yes.
Yes. 25.
Yes. Next week. As yours.
25, my lord, your lordship was pleased to issue notice to the opposite party number 2. Because there has been a compromise between the parties and they have got back all their entire amount. And they have also filed affidavits in the courts below saying that they do not want to proceed with the case, my lord.
Complete.
I think service is complete. Probably, my lord, the office might not have service ta but I pray, my lord, your lordship may direct the office to find out if anybody has appeared. If it appears, my lord, they can file an affidavit.
Notice was issued to opposite party number 2. The SR report indicates that service on the opposite party number 2 has already been effected. None appears from me in the interest of justice next week. Let us see otherwise.
Next week, and there is an interim order.
Interim order to continue.
26. Maybe yes.
My lord,
My lord, I am in
this
I'm for the opposite
In
party.
this case, this petitioner is a lady and is a Urdu primary school teacher. And the fact remains that opposite party number 2 has filed a 138 proceeding against them admittedly. And admittedly, there is
You are the accused.
I have reported and I could not give my defense, and now the case is posted for judgment without my defense and my argument. So only my sole submission before my lord that I may be given the judgment fixed by this trial court be deferred for 1 week, and in the meantime I may be given opportunity for giving my defense and to.
Yes. Yes,
My lord, may kindly see the order sheet. My associate is handing over. Your lordship may kindly see the order sheet.
Last day.
My lord, may kindly see, turn to page 9.
Okay. 9. Yes.
Order dated is 15/8/19. My lord, here my cross-examination was complete. Then your lordship may kindly turn to page 11.
What matter also?
Yes.
Order dated 15/10/19.
Yes, already.
Accused is absent but allowed to be represented, and complainant filed fresh power on behalf of such and such associated with counsel files a memo. Complaint, hence evidence of the side complainant is closed, put up for accused statement. Then your lordship may see 31/10/19 put up for accused statement. 18/11/19 put up for NBW. She did not appear thereafter. NBW was issued. Thereafter, my lord, it continued for many dates, and ultimately, my lord, your lordship may kindly turn to page 14.
Yes.
Order dated 12/1/21. As per the order, such and such stood as surety, files an affidavit for solvency. He is present, produce document, put up on date fixed for evidence, defense evidence. Then on 23/2/21, put up for defense evidence. Then my lord may kindly see the next page, page 16. Put up for defense evidence. 4/9/21.
My lord, admittedly since 2021.
5 times he has
Usually
put up for
trusted for defense.
2019, you were absconding. Thereafter.
But 2021 million that she has defaulted. Admittedly,
No,
by
19, NBW was issued against you.
Thereafter,
You kept on appearing to your counsel.
Thereafter, surrendered, thereafter, surrendered.
You have not done any grace. You are the accused in 138 matter. You have taken within 6 months. You are supposed to be over.
So my respectful submission would be that without my defense and
maybe because
only.
See how many opportunities were given.
So only the last opportunity
I'll just count for you. I'll just count for you. I'll just count for you 1 minute. I'll just count for you.
Only 1 week.
On 12/1/2021, first opportunity. And 15/2/2021, second opportunity. 23/2/2021, third opportunity. 7/5/2021, fourth one. 23/7/2021, fifth. 4/9/2021, sixth. 24/9/2021, seventh. 21/10/2021, eighth. 2/11/2021, ninth.
7/12/21.
And thereafter 7/12/21, 10th. This is how you are.
Then again she jumped bail.
In between you evaporated also.
My respectful submission would be that because of the illness and as well as for the school.
Where is your application? Where have you explained it? Show me. Where have you explained?
Nothing, my lord. Your lordship may kindly turn to page 22 for a moment.
1 minute.
Compilation.
One minute, Mr. Bose. Yes, where is your application? Where have you explained the defaults?
I have admitted.
You were ill or you could not appear. 10 opportunities were given, but I could not avail. Before that, there was NBW issued against me.
That I have averred.
Where?
That I have averred in me.
You show me. If there is any substance, then definitely I'll allow. Show me. Otherwise, no question.
Page 25 of the brief, my lord, nothing has been mentioned.
That without visuals to be able to submit that.
Where are you reading, sir? Where are you reading?
Page 11 of my book.
11. Okay. Yes.
That without visuals to be able.
1 minute.
13 minutes.
I'll just.
Without visuals to be able.
Let me reach there. Let me.
The petitioner surrendered.
1 minute, sir. Let me reach there. 11 of your petition now. You have filed, huh?
Mine.
Okay. Read it. Yes. I'm there. Yes. Yes.
That moved the bail and by the trial court instead of closing the defense evidence, controverting the complaint's allegations, whereafter the defense could have been closed, but since petitioners preferred to surrender independently without producing Annexure 1, the trial court passed the case for argument, ignoring the defendant. The fact, the background is that previously there was an NDW and this petition is before valid in earlier occasion before this Hon'Ble Court. And this Hon'Ble Court direct, I have annexed that Annexure 1, I have annexed. That in that case, my lord has directed to surrender before the court my at page,
I know.
at page 18 Miller. My lord, in that case-
Court gave you indulgence, your
Yes,
husband
yes,
was
yes,
cancelled.
yeah. But the fact remains that since the petitioner could not produce that order sheet before the trial court.
After cancellation of NBW, you appeared. Thereafter, you took 10 days. And you have not a word, a single word to explain why 10 days.
So
You show me anything where I can give you indulgence. Otherwise, routinely one cannot give you indulgence unless you say something that you are ill or some certificate you produce or some averment somewhere. There is none. Neither in this petition nor before I. Right.
My sole submission before my lord would be that only 7 days may be given, time may be given.
It's not possible, sir.
Decoding the judgment.
This is
In the
not
meantime, I will give my defense.
unless you show something on record, nothing is shown. It's not a routine job. In a 130 matter, you are accused.
I will point out, let it come tomorrow.
No, not to. Right now. Petitioner
I
is agreed.
will point out.
Petitioner is agreed by the order by which the agreed by the order dated one. Agreed by the order dated 3/4/2024 by which
with my lord's permission,
evidence has been closed. Mr. Bose, that counts for the opposite party, placed on record. Proceeding the court below.
with my lord's permission,
The court below, which indicates that
cost may be awarded.
which indicates that NBW was issued against the petitioner by order
4 times NBW was issued.
17/12/2021. 17/12/2021. The opposite party approached this court by filing CRLMC number 2855 of 2021. While order dated 28/7/2021, this court, although quashed the NBW, however, directed the petitioner to appear before the court below and contest the case. Subsequently, the petitioner, the opposite party, appeared before the court.
So my
313 statement, accused statement under section 313 was recorded. Thereafter, the petitioner appeared before the court below through his counsel and moved application under 317 CRPC. The trial court granted as many as 10 opportunity and kept on adjourning the matter for recording of different evidence. However, the opportunity given by the court below was not availed by the petitioner. Rather, the petitioner remained absent and NBW was again issued against him. NBW was again against him white order dated
My lord, 13/5/22, page 23.
here 13/5/2020. When the matter stood thus, the petitioner, the opposite party, moved application for seeking an opportunity to leave the defense evidence, which has been turned down by the court. I find no information. Taking into consideration
with my lord's permission,
for the petitioner, the conduct of the opposite party about being accused in a 138 no intention could be given by this court, hence this petition.
with my lord's permission, that
Even today there is NBW against you. Yes. Yes, sir.
Well, I'm appearing as 96. I am the petitioner.
And who is for
My land friend is appearing on the other side. He says that he has some difficulty. So why should I wait till 96?
The request of opposite party, matter is adjourned. Adjourned to also interim order to continue.
Interim order.
Entry order to continue.
No, no, your lordship may put it up after vacation.
After vacation only, not
Any day.
He will fix a date. Date will be fixed.
Acha, all right, yes,
Yes.
all right.
27.
27, my lord, there was a proposal for compromise is going on. Put it after vacation hours.
What is the offense, sir?
Offense 420, your lordship.
Call him. 420 call both the parties.
It after vacation hours, ଟିକେ ଚାଲିଛି proposal between compromise.
Okay. Right.
29. 29 after vacation, my lord.
Why?
I am unable to contact with the accused, my lord.
Yeah. Joint affidavit and everything.
Already filed.
The problem is you have taken interim order.
No interim order.
No interim order.
No, my lord.
Then let it come. Let it come.
Okay.
31. May I have your lordship? My lord, I have been DC from Raukla, my lord. My lord, I have filed this proceeding for quashing of criminal proceeding in GR case number 91 of 2021, wherein learned SGM has taken cognizance against the present petitioners under section 498A, 406 and 506, 34 of the IPC, my lord.
Yes.
My lord.
What is wrong in it? What is wrong in it?
Because the present petitioners are the parent-in-law and the daughter-in-law and aunt-in-law. Absolutely, I have not filed this petition for husband. This is the aunt-in-law. Absolutely, there is no allegation against the present petitioners as to what role played by the
It's a matrimonial dispute. I am only issuing notice. Let us see. Issue notice to opposite party number 2.
My lord.
Yes.
My lord.
Next.
32.
Yes. 32. Anybody say?
32.
Private party.
My lord, I am in VC, my lord.
Yes.
My lord, here there was a matrimonial dispute between the husband and the opposite party. They are husband and wife. The matrimonial dispute was closed. 17 lakhs compensation was awarded. Wife has challenged for enhancement of compensation and Mata is pending. Your lordship, while sitting with Justice Sinha, has also held that only it is confined to the challenge regarding permanent alimony. Divorce is not under challenge. Now what has happened? During pendency of the criminal Mata case, 125 proceeding was filed. In 125 proceeding, interim maintenance was awarded. That interim maintenance has been paid up to the decree of divorce. Now, my lord, no arrear is there, but she has levied an execution case after the disposal of the Mata case, the matrimonial case, to give to ask demand money after the decree of divorce and placing of the entire permanent alimony on record. She did not take permanent alimony. Thereafter, execution case has been filed asking for enhancement of money, which is not permissible because the 125 is confined to till decree of divorce.
In the execution proceeding, how can she ask for enhancement?
That is my point, my lord.
Where is that?
Yes,
She is asking for execution up to the order, not asking for enhancement.
No. My lord, I am sorry, I did not try to explain it properly. My lord, 125 order was there. 125 should have been culminated, granting 20,000 to the wife, 30,000 to the wife. My lord, after the till decree of divorce, I have paid the entire money. So after divorce, when permanent alimony has been settled, my point I have raised in the execution.
Perhaps you are trying to tell that once divorce is granted, permanent alimony is paid.
Yes.
Beyond the divorce date, no maintenance is required to be paid.
Yes,
that's
because
what you are saying.
Yes, that
I'll just issue notice. Issue notice.
My lord, execution may be stayed because she is proceeding with the execution.
Mr. Bose, then comes for submit that he would move appropriate application before the court below in the execution proceeding, seeking an adjournment owing to the fact that the present matter is sub judice before the court. Yes, next.
My lord, your lordship may only issue notice to the opposite party.
I have issued it.
Grateful. My lord, your lordship may only note the execution case number. Execution case number be noted.
Execution case number.
Yes.
Pass over.
Item 33 on behalf of Mr. Das.
What is this matter? Small matter?
He is less on other courts.
Okay.
34.
Yes, Mr. Raghuda, just see what is this value.
34.
Entire proceeding.
Matter.
Four 406.
Matter.
408.
Yeah.
Young boy. Because after lunch it may not be possible to. Huh?
35.
Yes. 35. Again. Display.
This one.
Show me the display.
For these reasons, these were not listed.
Huh?
For these reasons, these were not listed.
Sorry?
For these reasons, these were not listed. 48.
Nobody is coming. These are the 23 matters. Huh?
Yes.
These are fresh matters. Nobody is coming forward. Maybe adjourn is all right, but what happens is perhaps they are not interested. That is why it was never listed. I asked them to list all the matters so that we'll see whether it is still surviving or if the other matter which you are transferred. All the matters you keep it quickly. They may not come. None appears for the petitioner. None appears for the petitioner in the interest of justice. Either because the none appears for the petitioner in the interest of justice. Put it next week. If nobody comes forward, then we can dispose it upon next week. They may not be interested. Yes. Yes.
36.
May I please, Lords? Lords, petitioner challenges the rejection of 311 application, Lords. Lordship on the last occasion directed me to file the certified copy of the deposition of the PW6 that we see along with the 311 application, so also the questionnaire, my lords. The witness was examined at length, my lords, and was cross-examined. We missed out
You have extensively see one paragraph examination, chief, and you are just see 2 pages cross-examination. Thereafter also you are not satisfied.
Only one material contradiction. Lordship may see the questionnaire that I have attached, my lords. Thereafter, the application under section 311, and on the next page, my lords, 2 questions to be asked to PW6, my
When you
lords.
arrive at this spot,
My lords.
that is House of Sankar Mishra.
At Athagod, what was the health condition of the injured Swam Pragya, who subsequently succumbed to her injuries, and a case under charge sheet was filed under section 306, my lords.
What is the relevancy of this question?
My lords, with regard to
See page 13 of the matter, the impugnated order. Third line. Moreover, on verification of the entire deposition of PW6, it found that the questions which now defense wants to put have already been answered by the witness in
somehow or the other.
So
for
there is
that,
no
for
necessity
that,
to recall PW6.
for that, lordship, that paragraph, that confrontation that we want from the one, she is a vital witness, my lords. The backdrop of the case is, my lords, PW6 is the aunt of the deceased. The petitioner before my lords is the stepmother facing trial under section 306, my lords. The backdrop of the case is the father of the deceased subsequently married the present petitioner, and there was disaccord between the firstborn daughters and the present petitioner, my lords. Subsequently, due to her own,
This is the only question you want to ask.
Two questions only.
When you arrived at this spot,
what was the condition? Relevant with regard to
specifically stated before
that you have
not specifically stated before the IO.
This is for confrontation purpose, my lords. By the time, as per our
whether
defense
it's specifically said or not, you can see that What is the question? Second question has nothing.
Then second question one can come out from the.
You can ask IO.
From the IO, but subject, if we will not put it for confrontation to the
161 statement is there.
160.
He can.
It is already
do
there.
IO.
You can confront. So this question has no this thing. First
So
question
only-
is when you arrived at the spot, that is the house of so and so
Okay.
at Athgada.
What was the health condition of the injured?
Injured. Let us see where this question was.
On our arrival, we found some
Persons are gathered there. I inquired Swam Pragya regarding the incident of stroke injury. She replied, she is not eyewitness. She is eyewitness. She post occurrence witness. Kintu she goes, she somehow or the other has stated in 161. I heard from the deceased that he was subjected to mental cruelty by the present petitioner, my lords, for which that question is relevant. And so also the confrontation, my lords, by the time we are there, I inquired Swam Pragya regarding the injury, and she replied that since
Doctor is there. Doctor, you examined.
By the time doctor has been examined, and moreover,
First question could be answered by doctor only.
Moreover, my lords,
You are asking still about the health condition.
thereafter she was shifted to the.
Whatever you should put all these questions to doctor.
Doctor has been examined, my lords.
The first question should be directed towards the doctor. Second question should be directed towards the IU. These are the two questions.
Lords,
When it comes for the petitioner submits that the two question he intended to put to PW6. PW6 he can very well pose to the relevant witnesses and he seeks liberty for the same. With this liberty, the petition with this liberty, the liberty is granted. Accordingly, the application under 311 moved by the petitioner to recall PW6, which has been rejected by the trial court. No interference is called for. Accordingly, the petition is disposed of with the liberty.
two, my lords, the doctor has been examined, my lords. In the meantime, as PW11, so also has been cross-examined, my lords.
They are very irrelevant questions. This will not lead some relevant question you should have asked. Nothing is there. Yes.
38.
38 is not 38.
You do.
39.
39. Adjournment taken. 40. Item 40.
39 कौन आता?
Adjournment taken. Adjournment.
40. Yes, 40.
Item 40.
40. What is this?
Another my lord.
First time.
Order date 23, my lord. That is at Khake. Order dated 26/6/23. Passed in serial mission number 1959.
Yes.
Is at Slake.
Same petitioner.
Manoj Hussain.
Here
Manoj Hussain. Present petitioner.
Okay.
42.
40. This first time it is coming?
First time.
First time. Non-repeat for the petitioner in the interest of justice.
Sir.
Yes. 41.
42, 41 adjournment.
42. Yes, sir.
The release of vehicle, my lord.
Challenging the order dated 14/12/23, my lord, rejecting the application under section 457 of CRPC for release of vehicle by the learned judge.
You are accused or honor?
My lord.
You are accused.
Yes, my lord. Petitioner is the owner and the seized the TVS Jupiter 125 vehicle
and the same has been seized in a case under section 20B 2B of NDPS Act. 5 kg ganja was seized from the petitioner Mile vehicle laying in the police station since 6/12/22, my lord. And in the meantime, charge sheet has been submitted on 29/8/23, my lord. Petitioner has already been released on bail.
Yes, Mr. Lord.
Under the consider, my lord, the impugn order. Third page, my lord. Honorable Court in the following landmark judgments in case of Jitendra Kumar Digal versus State of Orissa, 2010 to 2020, wherein in similar situation where the petitioner was the accused in a NDPS case had approached to release the seized vehicle standing registered in his name, it was held that there stands the partial bar as the interim release of the vehicle seized in connection with the commission and transportation of narcotic drugs and psychoactive substance, and ultimately held that the prayer for interim release of the vehicle in sans merit. Here also the allegation against the accused person who was registered owner of seized vehicle that he used the same for the purpose of transportation of 5 kg ganja on the relevant day. So pursuant to the seizure, the petitioner has been arraigned as an accused to have committed the alleged offense, being in possession directly involved in the carriage and transportation of a NDPS substance in above a vehicle driven by him. As such, statutory presumption of culpable mental states, section 35 of the said act, and also presumption possession of NDPS article under section 54 of the above act also come into play for full strength from the beginning of the trial of this case, unless until it is satisfied, reverse, disproved by the accused person.
We have the decision of Basant Kumar Behra versus State in our High Court, my lord, relying the decisions of Amla Bhai Dosai's case, my lord. They release up. What
What is this vehicle?
My lord, vehicle TPS 125.
Motorcycle?
Yes, my lord.
Now which paragraph?
TPS Jupiter 125.
Which paragraph?
Scooty what hai?
Impugn order second paragraph. Impugn order second.
Confiscation, any proceeding is there?
That is not mentioned, my lord. Confiscation.
No, my lord. No confiscation proceeding is there.
And you have the decision Jitendra Kumar Digal, my lord, too. Can't be released, my lord.
Some case.
And section 35 and it's.
Whatever put reject.
5 kilo ganja.
5 kg.
No. The petitioner is agreed by the order dated 14/12/2023, whereby his application under section 457 CRPC in connection 415 CRPC for release of his which vehicle is this?
TVS Jupiter
125.
125.
Bearing registration or OD.
Number page 111 page 11 has been rejected. Petitioner is an accused in connection to the city special case special NDPS case number 19 of 2022. It is alleged that 5 kilo ganja was found from the conscious position of the petitioner while transporting in the vehicle in subject. The court below, by relying upon the judgment of Jitendra Kumar Digal versus State of Orissa, rejected the application, rejected his application. The cause for the petitioner, relying upon the judgment of this court in Basanto to emphasizing para to submits that value of the vehicle shall be diminished if the same is not eligible away.
release. Accordingly, the impugn order is set aside. The vehicle is directed to be released on the condition to be imposed by the court below, taking into consideration the judgment of this court in so on so forth. Yes, allowed. Yes.
43. I prayed for after vacation, my lord, compromise matter, my lord, the parties have not come.
Thank you.
44.
I'm extremely sorry, my lord, I could not clarify yesterday. My lord, this is related to, my lord, this is a compromise both parties, and this is a case and counter case. My lord, same day both parties has been, the lords was yesterday asked question who is the opposite party number 2. My lord,
whether compromise has been held?
Yes, both parties remain, all parties are present.
I am appealing for the informant lordship. Opposite party number 3.
Again. Two cases, my lord. Oh, the same day it is, my lord, I given the memo, your lordship, just let the same date.
The other case?
Your lordship?
Other case?
Pardon, lordship?
Which one is the other case?
My lord, other is annexure 2, your lordships. Annexure 1 is the, my lord, lodged by the, my lord, the in opposite party number 2, and annexure 2, my lord, is the issued by the, my lord, the same date, your lordship, kindly. They both are immediate neighbor and they are intend to settle the matter.
Who are the in annexure what?
Annexure 1 is the, my lord, related to, my lord, serial number 1, your lordships, which is registered under 3 SSC Act 354, 3
You are
SSC Act.
seeking quashing of annexure 1 or 2?
Both, my lord, all, my lord, this is the compromise, the 2 proceeding.
One.
That means one is
My lord,
case
both are
and counter
compromised,
case.
your lordship.
But that's right, but 2 FIR cannot be quashed in one.
Your lordship, may confined to 1, I will file, my lord. Observers, I will file to.
My lord, I mean case and counter case.
Case and counter.
So both cases you should file separate case.
That's the problem.
Yes.
My lord, both parties present in one, your lordship may quash one proceeding. I will file another proceeding.
Right. So the instance of opposite, who is number 2?
Come to the court.
Yes, party.
Maharaj sir is there.
Yes.
Who is number 2 in this case?
Petitioner number 2, your lordship. Petitioner number 2 is the, my lord, he is the, my lord, he is the, my lord, informant in the, who is the against the petitioner.
You forget about the other case.
Your lordship.
Talk about today you are seeking quashing of
annexure, my lord, the one case. Your lordship.
In annexure 1 FIR.
Your lordship.
Who are they? These are the two petitioner 1, 2 are accused.
1, your lordship.
Accused. Who is opposite party number 2?
Opposite, my lord, your lordship, opposite party number 3 is the informant. Opposite party number 2, your lordship, for the moment I am deleting.
That's what I am asking.
Yes, your lordship.
At the instance of opposite party number 3.
3, yes, sir.
3 FIR number Janapur PS case number 44 of 2012. 2012 under section 4.
My lord, 16 chari bar.
16 bar. I am giving the memo, your lordship.
16 bar.
Yes, ma'am.
16 bar. This is 1.
Yes.
With there is next paragraph. Who is the accused in the second FIR?
Second FIR, my lord, both the petitioner, your lordship. Both the petitioner. He is a count case and counter case, my lord.
FIR, the petitioners are accused.
Your lordships.
In second FIR, they must be informant.
The informants accused, my lord, the petitioner to opposite party 2 and 3, your lords.
Right. The in the by way of a cross FIR, the present petitioners have also lodged an FIR, being PS Janapur PS case number 45 of 2012 against the opposite party in the present. The petitioners have settled the dispute. Therefore, the petitioners have filed the present petition seeking quashing of both the FIR. This court is of the considered view that the conjoint application for quashing of both the FIRs in this present proceeding cannot be entertained.
Yes,
therefore, the present petition is only entertained for seeking quashing of FIR number 44, Janapur PS case number 44 of 2022. 2012.
And the informant is
for the party submit that they would be preferring a separate petition seeking quashing of FIR number, Janpur PS case number 45 of 2022 on the ground of settlement. The petitioner and opposite party number 3 are present in the court, being represented by their respective counsel and identified by them. They file the self-attested copy of their affidavit. The opposite party number 3 has filed an affidavit before this court, inter alia stating that she has settled the dispute with the petitioner, and there was a cross case registered against him at the instance of the petitioner. They have settled the dispute, both the disputes, though on the intervention of the village gentry and well-wishers. Therefore, she is not willing to prosecute the present petitioner in the instant FIR, namely Janpur PS case number 44 of 2012. Mr. Rahul, appearing for the state, submits that since the parties have settled their dispute, interstate dispute, and the case is pending since May, and the FIR was registered way back on 16/4/2012. There is no legal agreement taking into consideration hello. Petition liberty is granted to the petitioner to file petitioners to file a separate petition for quashing of FIR Janpur PS case number 45 of 2012. 45.
Petitioner being the complainant, challenging the order dated 3/2/2024, filed by the learned JMFC, and are dismissing the complaint petition, which the date is fixing for service of a copy of 205 petition, my lord. My lord, page 19, my lord. Lordship C. 3/2/24. The case record is put up today for service of copy of objection.
Page number 19, my lord.
My lord.
Last para.
Service of copy of objection, if any, from the side of a complainant on the petition under section 205 CRPC filed by the accused. The complainant is absent, and an advocate on behalf of the complainant is also absent on the repeated calls. No steps taken on the behalf of the complainant. Advocate on behalf of the accused present. File Hajira, and the case is viewed that not to start valuable time set as the expert. The complainant is showing interest in case. According to the case is dismissed, my lord. Without service.
Before that also complainant was upset.
My lord.
Once a petitioner was not present at the time of 205
even if
statement recording.
Even if not.
Neither advocate nor.
Last day, one day, huh? What was the complaint? Complaint?
Complaint under section 138 NI Act, my lord. Even if non-compliance of the non-appearance of the complainant, my lord, court can proceed the case, my lord.
The petitioner is agreed by the order dated 3/2/2024 passed by the court of NGN JMFC Raj Nagar, whereby his complaint under section 138 NI Act against the opposite party has been rejected, has been dismissed. It appears from the record that the opposite parties have moved an application under section 205 CRPC. And the petitioner was directed, petitioner being the complainant, was directed to file objection to the said application. On 3/2/2024, the complainant could not file the complainant did not file the objection to the application under section 205 CRPC.
205 petition, even if 205 petition not received.
On the ground that the copy of the application was not available with him, not available with him. On that day, the complainant, neither the complainant nor his advocate were present to prosecute the case. Therefore, the complaint has been dismissed by the court. What is the check amount?
6 lakhs.
Having taken into consideration the facts.
6,78,000.
And after perusal of the impugn order, I am of the conclusion to you that the impugn order is the complaint case dismissed by the court below is not sustainable under law and fair. Hence, the impugn order dated 3/2/2024 is set aside, and the complaint case is restored to its original file. The trial court is directed to issue notice to the opposite party and proceed with the complaint. Allowed.
46. What is that matter, my lord? The gal is deep down. Murder and the compromising investigation going on. IOG appearing, my lord.
That deaf and dumb.
My lord. What happened in this case, my lord? Helping, taking it.
File a better affidavit. Give details.
The ground of settlement has already been mentioned. That is
Ground of settlement also.
Only I have not mentioned with regards to marriage of the victim. I will disclose the married to person who is married.
You may not disclose that, but you can very well write. Don't write the name of the husband. You can
Yes.
very well write she has married
Yes, yes.
elsewhere and settle.
and her marital life will be spoiled if we proceed with that.
I will
At
mention.
least,
Yes,
at
yes.
least something, you know.
Yes, yes. Fine.
48.
May it please be your lordship. Your lordship, this matter had come before your lordship as fresh admission, and your lordship had pleased to issue notice in this matter. This is pertinent to quashing of application of 138 proceeding.
The opposite party
Notice has been issued, but I have mentioned it because stay application was not heard since I have failed to file appropriate
You are
document.
the accused.
Yes, your lordship. I am the accused. My primary ground of assailing this cognizance order is as a managing director, I have issued the check, but they have not arrayed company as an accused. So the whole proceeding is vitiated and the yes, your lord.
That a counsel for the petitioner submits that he had assailed the complaint
Yes.
petition before this court initiated against him under section 138 NI Act without including the company as a co-accused. Notice was issued to opposite party number 2 on 9/4/2024, and service is awaited. Service is awaited. At this stage, the petitioner has moved an application for seeking stay up for the trial court proceeding. The application is allowed. The proceeding, further proceeding in ICC
One
bracket NI number 13 of 2023 pending before which court?
SDJ, learned SDJM Burger.
Burger is stay. Yes.
Obliged, grateful. Your lordship.
103, my lord. Compromise, but both parties are present, my lord. My lord, thrice it has been urgent, my lord, for their presence.
Huh?
Thrice urgent, they could not appear for today. They
Yes,
are
bring them.
490. 490.
Call them. 10.
Joint
Three.
103, item 1.
Item 49, there is a compromise matter, but the parties are not appear before a lordship. The lordship may can be taken on any other.
File only simply a handwritten
That is the compromise before their community.
issue notice to
Issue, I have already filed the notice.
FIR is
FIR is annex to 1.
bring them. What is the problem?
For which
When?
Lordship can leave 5 to 6 next week.
See, you have taken so many dates, yeah.
Oh,
Two dates you have
two
already.
days. Yes.
Really, they have settled or not?
Already settled because
Why don't they appear
It's coming from Burger. That's why the case is listed specifically directed to listed on 1st May, but that was not listed on
Okay,
for which
when do you want? Next week?
next week.
14. One.
Yes. Obliged to Lordship.
50.
50, my lord, your lordship is directed issue notice in other cases, my lord. This is arising out of a civil dispute, my lord. Your lordship is directed in 3 cases, my lord. And I am
Hey, the other 3 cases are
3 cases, same informant and accused person the same, my lord. And another 3 cases is yet to be listed, my lord. Your lordship has already directed for issue notice to the informant, my lord. Se pode ଆସିବି ମୁଁ ଦେଇଦେବି ସେଗୁଡାକ I will provide the list, my lord.
You change the dates.
Yes, I have changed, my lord.
Same order.
Same order, my lord.
Tag kar this Khatri, yeah?
And another matters are there, my lord. I will also keep
Keep the numbers they will take.
My lord.
51. May I please, your lordship? This application has filed to quash the entire proceedings and FIR. My lord, allegation against me is that I have assaulted the present informant and he sustained some bleeding injuries. And also it is further alleged that I have abused him with filthy languages, pointing out his lower caste. My lord, in the meanwhile, the matter has been settled between both the parties in front of the villagers, and the villagers have taken initiative to maintain the peace in the village.
Where are they?
No, my lord, it's a fresh admission case. Kindly, my lord, kindly issue notice the.
Issue notice to open the
Yes, my lord. Obliged, lord.
52. Yes.
My lord, may I please, your lordship? My lord, I am filing this petition for release of the account, my lord, defreezed, that is freezed by the bank on the basis of the report of the IAC in connection with my lord FIR under Annexure 1. My lord.
You are accused.
My lord, I am accused in my lord that case, but the IAC, my lord, without any intimation, my lord, to the present petitioner also informed the bank to freeze the account.
Part of the investigation.
But right now, what is the status of the case, my lord?
Get this set. Mr. Rahul then calls for the opposite party state seeks time to get the instruction in this matter. Urgent. Yes.
Matter.
53. Compromise matter, my lord, informant. When the 3 petitioners are before my lord. And informant injured 2 and 3.
Injury report.
Injury report is, your lordship has simple in nature, your lordship have a glance page 36, your lordship. Simple in nature, 36. Lipuna Maharana. In my petition, 36 page, running page.
54?
36.
No, your item number.
53.
Oh. So 36. Where does it say simple?
My lord,
Yes.
weapon, hard and blunt, simple. Lordship.
2, 3, 4, 5, 6, 7, 7th line.
Simple.
Simple. Yes.
Who is the injured?
Injured, my lord, son.
Lipana.
Lipuna.
And informant is
His mother. His mother.
Mother is the informant.
My lord.
Right up. And the instance of opposite party number 2. FIR also came to be registered against the petitioner. In the FIR, it is that on 21/5/2017, it's about 9 p.m. The informant son, that is the opposite party number 3, had gone to a Bharat party of one Pintu Vishwa to the village Roha Mandi. Brahman.
But for the complainant, no advocate is there.
Who will identify?
This one, they the affidavit, my lord, I will file.
Vokalatnama.
Bakalatnama affidavit.
Are you sure that they
Yes, my lord, in 2 o'clock thereafter, your lordship.
I'll take.
You detect the order and I.
Okay,
I will serve.
Do one thing. Get in the Vokalatnama and engage someone filing.
My lord, already.
You can identify and give you. Yes.
54. Here, my lord, my prayer is for early disposal of the GR case, my lord. Now, if the case is in the year 2018, the FIR is unknown, but subsequently I am implicated in the case. I am a government servant. Since 2018, the matter is pending, for which, my lord, I am suffering a lot, my lord. My promotion held off and I am suspended from the service, my lord.
Yes, my lord. Petitioner submits that he is a petitioner is an accused in FIR number 4. The FIR was registered on 19, next program. FIR was registered on 19/4/2020 to 18. Where the charge sheet was filed on?
Charge sheet was filed on. Just a minute, my lord. Charge sheet filed on page 13.
Tell me the date.
No, I am just. Charge sheet filed on 20/25/2023, man.
2023.
Charge sheet number 264/20.
Why the cognizance is taken in the year 23?
My lord.
5/6/23. The cognizance for offence under section so was taken by the court below on 5/6/2023. The petitioner submits, accounting for the petitioner submits that he is a government employee.
Mother.
He tried to be government employee. Due to the prolongation of the trial, he services and prolongation of time, he has been suffering. Hence, he is in the service. Free fair and speedy trial being the constitutional right of court. Is entitled for the speedy trial. Accordingly, the grade is allowed, and the trial court is directed to do well to see what the trial is concluded.
My lord, preferable within, my lord, 2 months or 3 months.
How many witnesses are there?
My lord, there is 18 witnesses.
Well, how will I get? You have not filed the charge sheet.
My charge sheet copy is there.
I don't know. Why I will not do that. Don't see. You don't know the when this is filed. 2023 cognizance is taken.
My lord, they have taken, my lord, 5 years, my lord.
Expeditious trial, then you must tell me what are the witnesses.
My lord, they have taken 5 years, my lord, to, my lord, file the charge sheet, my lord. That is the difficulty, my lord.
I give you that.
Next 55.
Yes.
My lord, in this case, application filed for modification of the order. The order passed the special court district of Bhubaneswar, and the vehicle is released with heavy terms and conditions. Only my heavy terms and conditions. That is the answer to see. Lord, you see.
What are the conditions you are
Conditions, so many conditions is there. So many conditions in the order sheet page number 43.
Which condition you are?
And I am condition VA 67. The petition shall furnish cash security rupees 30,000 along with the property security of 1 lakh and indemnity bond 50,000. The petition is the auto rickshaw age of the auto rickshaw is 13 years, and the value is very low, and the cost is very difficult to repayment, and he is only source of income.
Cash security of 30,000, 1 lakh indemnity bond. Property security 1 lakh. What is the offence?
Offence, my lord, 20B 2C. NDPS.
Vehicle was released.
Yes, my lord.
Auto rickshaw.
Vehicle has been seized, my lord. And
vehicle already.
What is recovered? Contraband. Ganja.
Yes, my lord.
How much?
My lord,
Just 21 kg, that
Huh?
very small 21 kg.
How much? 21 feet.
It reflecting Karini because of
You tell me
Yes, ma'am.
to see how.
22 kg for us.
22.
Yes.
Sure.
I am confused.
Well, that has not been mentioned in the.
If you don't assist me, then how can I pass any order?
That is not also in the order city also reflect there.
You must know, sir. If you are trying to
That is 20, 22 or 23.
No, where you have
Nothing is
mentioned
there.
here.
22 perhaps. 22.
No. I will not pass the order on the basis of tariffs.
Let's say the Torman condition is very heavy, so he only the carrying the passenger and the only source of carrying the passenger and service.
Everything is all right, but I need
The order is indulged in this order, they cannot release the vehicles. More than 1 year already in the
Don't
open
understand
sky.
what I
And my lord's question is that how many kg contraband has been seized
Yes.
from this auto? You did not mention that.
You have no idea. You must tell me so that I will alter that order.
କେତେ ଦେଇଥିଲେ କହିଦିଅନ୍ତୁ.
Very pathetic. You basic thing you don't know, then how you speak? Adjourn it to after vacation. Yes, next.
Next week, let's say next week I will produce. Because of more than 1 year that is in open sky and then that.
Sir, if you don't assist me, how can I pass the order? You tell me.
Next week. Let's say next week. I can produce.
Next week, how many meter I can take?
Yes.
A date, you have wasted time. Only you have to tell me how many kgs seeds from you. That much you don't assist.
ସେତିକି ଜାଣିଥିଲେ sir.
I will produce it next week.
No, let it come after vacation. I can't help it. How many meters one can take? 100, 200 meters like this. 56. I expect at least minimum assistance so that I can pass the order.
I'm sorry, I'm pardon.
Yes, next 56. I am passing it over and get the information. I'll dispose it up.
Yes.
ଏବେ ଦେଇଦିଅନ୍ତୁ ବୁଝିକି.
ମୁଁ ଏବେ ବୁଝିକି ତ ବୁଝିବି.
After lunch, I'll take it up. Get the information. Yes. 56. Please, my lord. Indemnity bond, Mr. Rahul.
My lord.
Let him furnish indemnity bond.
Yes,
Where
my
now
lord.
it?
Yes, my lord. Yes, my lord. Little or auto, my lord.
The 30,000 I will case security and that security I will waive. Let him file indemnity bond.
Yes, yes.
ହେଲା ଆପଣ ବୁଝିକି କୁହନ୍ତୁ.
ବୁଝିକି କୁହନ୍ତୁ. If small amount ଅଛି, if it is a small amount, then the 30,000 cash security and property security of 1 lakh I will waive. You file the indemnity bond and take it. If it is a large quantity, then I will not enter.
No, very small quantity.
You
ଆପଣ
tell
ବୁଝିକି
me
କୁହନ୍ତୁ.
exact.
ଆପଣ ଟିକେ authentically ବୁଝିକି କୁହନ୍ତୁ.
Yes.
56. My lord, rejection of 311%. It's
11.
Yes, my lord.
311.
PW4 will be recalled as see the victim. And question is at page 6, my lord, which is to be put to the victim.
Page 6.
Page 6 of the
victim, my
question
lord.
is. The previous counsel who was conducted the case has not put some questions,
Pokso.
relevant questions, my lord.
Pokso, no?
Pokso, yes, my lord. Only chance may be given because
35, 33 clause 5.
Yes, my lord.
You can
here, my lord.
you can call the mother or whoever. it is,
Legally
but
bar
not
is
the
there.
Victim. There is a bar. That's the problem. There is a bar, sir. What are the questions regarding?
The source of generation of nude photographs and regarding knowledge of.
It was released by the law and STGM. They prefer and revision. Revisited, revision also dismiss. I have in between I have filed 2 CLMP application and last after getting the notice from the CLMP application, this 482 application was filed. And last occasion your lordship has stated that basing upon which judgment the law and STGM released the vehicle manual, that is Arun Kumar Agrawal. I have to cite that judgment.
I'll just hear it after, immediately after the case. It continue. Continue. This hearing will continue at 2 o'clock.
After lunch.
2 o'clock.
May I please, Lordship? Item number 110 minutes. May I please, Lordship, call it some other date minutes? I have a difficulty.
Fresh matter.
No, fresh matter. Entry models to continue. Minutes. I'll inform the other side. Deeply placed.
Finally, it may not take place.
No, that's why I'm saying that after that.
This is the revision.
No, 482.
Entry model is there.
Entry model.
Who is the other side?
Yes. Next week, any day.
He'll give date. Yes.
Item number 60 permitted to withdraw.
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 Memo. You give the memo.
Item कितना?
In my matter, entry model.
No, he will give the date. Entry model will continue. Whether in opposition.
I'm good.
Yes, it is very
learned friend, he was making the submission, he missed out on the IA, my lord, to place the IA to stay on further
50.
proceeding. Item 51, my lord.
Which one? What happened?
Item 15 matters are order for notice.
She needs to place the IA. First step. Notice has been issued. I can't hear it right now.
My lord, then
You move another
you may
application.
fix a short date, my lord.
Short date he'll fix. No. Yes. Next.
May I be pardoned to make a mention, my lords? I'm
Item
on
number
VC.
100?
104, my lord. It is a compromise matter. Victim has the aspirant.
Yes.
May I be pardoned to make a mention, my lords? I'm on VC.
Yes.
My lords, there's a CLMC which has been filed on 9th of April, my lords. The lower court date is posted to Tuesday, my lords. My lords, may kindly allow I've filed a memo, my lords. May kindly be
should have
listed
been, this should
tomorrow.
have been mentioned in the morning, not that.
This has been mentioned.
Give the memo. Give the memo. We'll see.
My lords, may kindly direct it to be listed, my lords, tomorrow. If
Give the memo. We'll see.
my lords.
One
Great.
matter, item 92, in fact, Belgium matter, it was disposed of as allowed. Time limit was given, but inadvertently I have written that in case of PSK, that is, they are wrong.
Correction.
Yeah. I've given the IA detail
I'll
mudechi.
take it up.
Yeah.
I'll take it up.
Yes, sir. As you lord.
57 minute was continued. 57 was continued.
Yes, 57. It was going on, no? Yes.
My lord.
Yes.
This present petition, my lord, application was filed by the state challenging that revisional order, my lord. Where, my lord, that was dismissed by the session judge. It was allowed in my favor that vehicle release.
Releasing the vehicle.
My lord, your lordship.
Now they filed 482.
482.
Challenge. It was not complied, therefore you went to some other court.
Yes.
Some other court asked to comply.
Yes.
So therefore they filed
in between they filed.
London SDM has directed to be released on the vehicle. Accepted that the configuration position is pending. That is the fact pending of the London SDM. Now that challenging the state case, the revision application filed by the state before the session judge.
Which was turned down.
Session judge rejected on the ground without observing anything on the merits of the case, then it's not maintainable. Revision is not maintainable. Number two. Number three, challenging that revision application which has been dismissed on the ground that is not maintainable, report this application before us. 2 points is to be considered. One, whether the order passed by the London SDM is right during pendency of configuration of the building, release of the vehicle is right or not, that is to be decided. Number two, your lordship observed that you don't go for that revision is not maintainable or maintainable, you forget it and just place satisfy me whether it is illegal or legal.
No.
So my prayer before your lordship and the
Question is,
yes,
if there is confiscation proceeding pending, whether 457 should be allowed or not. That
Yes,
is
sir. That is the sole ground. And
that is
why going here and there?
I have given the decisions.
Give me this. If it is maintainable, maintainable. It is not maintainable, not maintainable. That's simple.
So your lordship can you see this decision? Check side. Your lordship see parata can you say parata?
It
say parata. Last parata.
Ashwinita.
Yes.
My lord.
Last parata can you take.
Remitting the matter to James to decide the application afresh after calling the confiscation proceeding 5. And this would be for the purpose of substantively satisfy the confiscation proceeding was in fact pending at the time of arrest. So this court has remanded back to only see whether it was pending at the time of passing. And what is this judgment?
That is not, your lordship, no.
That is it case.
My lord, my humble submission, my lord, the learned.
Show me your.
My, and that Arun Kumar Agrawal has given.
Arun Kumar.
Your lordship, basing up.
Yes,
Arun Kumar Agrawal, my lord, state of Orissa.
yes.
My lord, basing upon this judgment, my lord, the London SPGM released the bill. Here the case is, my lord, your lordship can have back to paragraph 3, my lord.
Yes.
It is seen that the improved order that application filed by the petitioner on section 40 for release of the seized vehicle has been rejected by the STGM on the ground that confiscation proceeding height were number such and such is pending.
I told you to locate one of my judgment. Where is that?
That judgment, my lord, I have searched. I have also asked your staff, but they.
I have passed an order in this.
And my lord, what my.
Yes, anyway. Yes.
It was squarely covered by my case, my paragraph 3, your lordship, confiscation pending. Your lordship, then my lord, it is under the Forest Act. Then your lordship, paragraph 7, page 5.
Yes.
The learned single judge has relied upon the division bench, Ashish Ranjan Mahanti versus State of Police. And your lordship, then page 6, man. Paragraph 16, man.
Yes.
Clause 1. Vehicles involved in an offense may be released either to the rightful owner or any person authorized by the rightful owner. This is the judgment man related to Ashish Ranjan Mahanti. Then you will see. It is an interim custody, not release for the some manner. If a person to whom the interim custody of the property vehicle is granted is ultimately found not entitled to it and unable to return it, its value shall be recovered by enforcing the bonds and the security taken from such person or recovering the monetary value from him as areas of the land. Next, my lord. Next page, page 8.
Yes.
From top, my lord, 4 line. Hence, lordship, hence, keeping in view the fact that vehicle are in stationary condition, either at the police station or at the forest range officer, this court of the view that the same would not be beneficial to both the owner of the vehicle as well as the revenue. On the contrary, the vehicle is released interimly in favor of the true owner thereof on certain terms and conditions, then the vehicle will not only be maintained properly, but the vehicle will not lose its value drastically.
Ultimately, it is allowed.
Allowed. And my learned friend has decided on a decision by Justice Sankar Mishra. And in a similar situation, my lord, vehicle was released. State filed an application before this honorable court, and the petitioner also filed an application for not releasing. And this is the case decided. And confiscation proceeding closed. Vehicle was confiscated. Despite that, my lord, this honorable court has released the vehicle since FAO is pending. My lord. Your lordship may can have glance to page paragraph 2, my lord. And this is also Forest Act. 2 cases, my lord. This was taken up by the learned Singh, Justice, my lord, Sankar Mishra, my lord. And he had, despite of confiscation, he finished. He has released the vehicle.
The order was, the vehicle was confiscated.
Yes.
Yes, Mr. Maharaj, he is covered.
That I have given my decisions and
this
is not the single decision, my lord. Divergent view has been carried out.
What do you want? Shall I send it to a larger bench?
No, the larger.
These are the principles have been decided by various courts.
There are judgments one after another.
That is all.
See, one judgment by one bench. He passed on 20th May 2022. And Ashwini was passed in 22. And now this judgment is 23.
But Venus,
And
I want that view.
he has also
That-
relaxed his judgment.
I don't know, my lord.
And
These are the circumstances and these are the finding. My case is finding is that admittedly it is finding that constitutional proceeding is pending. But still, there is a bar. So bar, can it be?
But the judgment say that you can proceed.
Yes.
I'm allowing it.
Your lordship, please.
I'm dismissing it.
Your lordship, please. I have already given my decision.
Where the judgment, the recent judgment is Justice Satyakant Mishra's judgment. 2023. I'll have to follow that. The one which you are relying is 2022.
Yes.
Do you have any judgment recently 2024 or something?
Yes, your lordship have got the Guruda bag, my lordship decision. 13 February 2024.
Take it out.
Number
This matter was urgent thrice, only to locate, but he is not located.
I have searched all the judgment of your lordships.
13 February 2024.
He would have did.
And if your lordship, that Ashwini Das, my friend.
Ashwini, I have also. Conflicting views. But
Ma'am, there is conflict, but my lord, this is the end. But after deliver of judgment by the division bench, my lord.
Yes.
That assists Ranjan Mahanti, my lord. Yes, there is a bar, my lord. But once a judgment passed by the division bench, my lord, that vehicle should be released, interim release, not finally.
Interim.
All the learned single judge has followed that assist Ranjan Mahanti, which are delivered by Honorable Chief Justice.
Yes.
Yes.
58.
Compromise.
I'm referring to the informant, my lord. I'll aspect my
injury.
Injury simple.
Injury report.
Report nahi. Affidavit.
Mr. Maharaj, injury.
Injury.
307.
Both the party, all the party are present.
Party may be there.
Injury report achi ki?
No,
injury.
Whether it's simple injury or what?
Simple injury will lekha hai.
Put lekha hai.
Affidavit lekhi simple injury.
You might have said that you are gentleman also.
ABLPL
You are not gentleman.
one of the ABLPL is pending, man.
That is why they settle. You show me something where I can get the this thing that injuries are simple. Who is the victim here?
In Malaya Deuri.
Injured na.
Yes, Malaya Deuri.
Who
is the informant?
Come this way. Pochara to kono male.
Deep achi. Head injury is there. Deep achi. Might be devious. But deep achi.
Deep. Head injury.
Head injury.
कायरे मारले
तुम्हें कौन तुमको रहता है खेली तो लेकिन
जहाँ एलिगेशन करता बेटा को ना ये वाले कौन है खेली माना मैं हटा रहा हूँ वाली
That matter is amicable settle.
खेला पहला
ठेले देला
लेटर्स से तो मानुचे
ବନ୍ଧୁକ ପଛପଟୁ ମୁଣ୍ଡରେ ମାରିଲେ
हाँ 25 आर मार्क टच पर
गन बट
ଗନ୍ ର ପଛପଟ that is the both have
investigation is on.
yes my lord.
Do you have anything?
No, nothing, only simply that affair is annexed. 24 my lord. Yes.
Let it be on Monday. You tell me the injury.
Injury.
Let it be on Monday. We have to see the injury. Where is the 307 and using gun? How many cases are there against these people?
No, petitioner. Petitioner against petitioner, no other.
Accused persons.
Yes, the accused persons are petitioners before.
How many cases are there?
They have no other case.
କେତେ କେସ୍ ଅଛି ମାନ ଥାଏ ଆଉ କଣ କେସ୍ ଅଛି ସେମାନଙ୍କୁ ତମ ଉପରେ କେତେଟା କେସ୍ ଅଛି
ଗୋଟେ ଗ୍ରୁପରେ ତାଙ୍କର ଇଲେକ୍ସନ ପାଇଁ ତାଙ୍କ ଭିତରେ ବାଡା ପିଟା ଆସିଗଲା ଇଲେକ୍ସନ ମାନେ ଏବେ ଚାଲିଲା ତାଙ୍କ ଭିତରେ
गोटिए village.
गोटिए का
What is it?
Compromise करते हैं कौन
At the instance of opposite party number 2, who is victim in the insult case, FIR number so came to register against the petitioner. Investigation is still going. Mr. Mahapatra led counsel for the petitioner. The parties are present in the court. All the parties? Yes, all three of the parties are present in the court. They are being represented by their respective counsel and being identified with and filed.
Saurabh Ranjan.
Okay.
Atish Kumar.
Mr.
Tapan Patnaik.
Mr. Mahapatra and Mr. Government would be for the party. That the injury sustained by opposite party number 2 is simply negative. The parties have settled the dispute because they are the neighbors and to maintain peace and tranquility in the area and on the intervention of the elders in the family and village gentry, they have entered into a settlement. The petitioner and opposite party number 2 have filed a joint affidavit. Inter alia, joint affidavit dated 2/5/2024. Inter alia stating that stating that due to misunderstanding, the FIR was registered, and they both of them are both the petitioner and the opposite party number 2 are friends. Therefore, they have settled their dispute. The opposite party number 2 is not interested to proceed with the petitioners anymore. Mr. Rahul, Mr. Maharaja and Mr. Rahul appealing for the state submits that the investigation is still on. At the very threshold, the parties have settled the dispute. The injury is stated to be simple in nature. Therefore, there is no legal impediment in crossing the FIR at this stage.
As pictures are submitted that the injury is.
I've written it. Jointly submits that injury.
Affidavit. Yes, joint affidavit.
Stated to be here. This is Mr. Maharaja's statement, and the injury stated to be simple in right. Taking into consideration the Jansi and Jansi and subject to how much you would pay to the three of you would pay subject to you beaten him. How much? 2,000 each, three of you. Subject to each petitioner paying 2,000 rupees to the injured, that is opposite party number 2. The FIR 6,000 rupees you pay right now.
In total, 5,000. In total, 5,000.
5,000 rupees total. 5,000 rupees in total. You pay him. 5,000 taka temane debe. And file the receipt again. File the receipt today itself.
Yes, sir.
Go pay outside and
receipt. Yes, sir.
And
receipt.
Apple never.
And
50
injured.
Oh, like.
First over item 6. Item 6. After that arrangement, nobody appear. That's urgent.
What is this matter about?
But the matter belongs to my lord state of West Bengal, my lord. Highly here for quashing of the proceeding. How can my lord?
On the second call.
Page,
the matter was called
page
in
10 matter prayer.
Called in the first session of the court, first session of the court. Nobody appeared. After Passover, the second time when the matter was called up, nobody appeared. Nobody
Page 10
appeared
matter,
on
page
behalf-
10.
On
Prayer
behalf of who? The petitioner. Page
10 matter. And the petition matter. The prayer. Graciously be
Page
pleased
10.
to enough allow this petition and quash or set aside the entire initiation of a CS number 79958 thereby in Metropolitan Magistrate 12th
Right.
Court,
In the
Kolkata.
present petition, petitioners are seeking the washing up the CS case number 79258 of 2022 pending in the Metropolitan Magistrate 12th
Madam.
Court, Kolkata. Kolkata. This court has no jurisdiction, has no jurisdiction to entertain this petition, hence the petition is dismissed.
Item 10.
That's item 10. The respondent number 2 is.
Your Lord, the petitioner is the borrower. He has mortgaged the property. And
you have settled the dispute.
yeah, amount has been paid. Entire amount has been paid.
Who is appearing for
Sir, I am from State Bank of India. What happened? In 2013, he has availed the loan to the tune of 1.35 crores and depositing a title deed. And that title deed is a void title deed because that title deed what he has purchased from a scheduled caste by suppressing the fact.
You simply tell me whether you settled the dispute or not.
No, settled dispute with a compromise of 70 lakhs against 1.52 crore for the suit file. Question last time your lordship told me that whether when he has made the compromise, whether he has agreed that bank will not withdraw. That paper I am submitting your lordship. He has already agreed that bank will not withdraw the criminal cases. Despite that, your lordship kindly see.
That was the condition. What can be?
That your lordship asked me. Page 2, point number B, my lord. Your lordship kindly see. 3 terms have been spelled out. First point is
OTS is something different.
Yeah. No, this is not OTS. What happened?
No, OTS, that is a civil transaction.
Yeah.
But here they have not agreed that the criminal case will
Then, Millard, I am reading out.
What happened, Millard? Because bank will not withdraw the FIR oblique case
filed by UOW even after
settlement of
through compromise.
Yes.
Your lordship raised this quite. So that is the only question. And you
I filed an additional affidavit. What happened? The bank has way back in the year 2018 said that the mortgaged property is not the legal purchase of the petitioner. That part was not within the knowledge of the petitioner. It is on filing of the application for availing the loan below, legal opinion was sought for. Legal opinion in all through below, in all through legal opinion, and the officials have said that the deed is valid below. Because the vendor of the petitioner has suppressed his cash that in the first Khatian below. If your lordship may kindly glance additional affidavit, in the Khatian itself, they have not disclosed the cash. Subsequently, my lord, that deed was that property was transferred to the petitioner.
Who are you?
I am the purchaser. That property was mortgaged, and in lieu of that, I have taken loan. And in the year 2018, my lord, my business was closed, for which I did not pay the installment.
You want to argue on merits?
Yes.
The compromise is ruled out.
The compromise one part. This is in between. So far, the bank has taken a plea that purchase deed is
bank is the complainant.
Yes. My lord, I will come to point. What happened? He has purchased the property and mortgaged in 2013. Prior to that, he has already filed a civil suit on the same title deed. That
I know. On merit, I am not going to.
Yes. My lord, the conduct and merit of the.
See, on 31/1/2024, I issued notice recording that the dispute is between bank and the petitioner. Since the parties have now settled the dispute, issue notice to opposite party 2 and 3.
Yes, Miller, Miller.
Now he entered appearance, he says that although the money transaction has been settled, but insofar as the criminal case is concerned, very specifically we said that it will not be quashed.
Correct.
Then
In the DRT, my lord, in the DRT, one application has been filed at the instance of the
you
bank.
want to persuade them to change this.
Millard, what I'm saying, your lordship, see, last occasion you are directed to what suit you have filed against that, knowing very
Entire
well
document,
he has
no.
deposited.
Entire document I have filed in the additional affidavit. In the FIR subset, this FIR, my lord, so far as the annexed one FIR, my lord, during investigation of this FIR, my lord, another case was instituted by the police official. That EOW police official said that this petitioner has been cheated by the vendor, my lord. Your lordship may kindly
All the
glance.
things are different.
Millard, I'm coming to Millard saying one thing. When he has purchased the property in 2003 and thereafter he has filed a civil suit, knowing very well that this title deed is a void title deed and he has knowingly very well and deposited in the bank and to cheat the bank. So that is why the fraud committed, and you see the misdemeanor and the gravity of the offense he is doing with the bank, and accordingly he has no knowledge. There is charge sheet filed already. Mirror prima facie case is proved, everything is there. Now trial will be commenced. So there is no need to.
I am the petitioner. Let me
No, petitioner is, we have also right to submit. No, we are submitting the knowing fully well. You have deposited to cheat the bank. You say you have not filed a civil suit challenging that. And then after knowing how you have filed in 2013 by availing loan, and then when it is NPA, you know very well, then NPA, we have investigated it, police investigated, and then complicity is proved. Now he has come. Earlier, he has also filed a petition before the Chief Justice and or single judge, that has been withdrawn also in this case. Again, yes, that is on the record. That is on the record, sir. So your lordship to conclude it, because there is no.
Yes, you have made your point.
Yeah.
That he wants to say something.
Hi, Millard.
So you please sit down.
Millard.
You have done as much as damage you could have done. Yes.
Okay. Sir, during investigation of present FIR, my lord, the EOW find that
you want to argue on merits. Compromise is no question.
Compromise one, but so far my submission is that if at all, my lord, that document is fraud, my lord, that is lost cause to me, my lord, not on the bank, my lord. So because bank has already got the money. And that has been settled. So DRT.
See, money is something different. The crime is something different.
Yes, so
the crime has been committed. What he says is, in 2013 you filed a suit. You had knowledge.
No. Suit is altogether different. After transaction of sale deed, my lord, legal heirs of that Khatian law, they have executed another power of attorney.
Don't you think that these are the things the trial court is going to? I can't go into.
Your lordship may put some other day, my lord, I will satisfy. I will
No, my lord.
note of submission, I will satisfy. And
No, Millard, to conclude it, Millard. I am folded hand because last 3-4 months. But if he has submission, yes, matter to be concluded.
And I am keeping it next week because I am not satisfied.
No, Millard, what he said, he should file a written note of submission. Matter may conclude it. Already your lordship had me extensively. So he should file a written note of submission. Matter should be concluded and judgment may be resolved.
You come on 20th. 20th, 20th. It's made clear that the counsel petitioner seeks time to file written submission. He may do so, and at least the veterans also. It made clear that no further adjournment shall be given.
Yeah.
I guess I add some other points.
Yes.
33.
Only person, right? Adjourn. Yeah.
53. Compromise already affidavit filed, my lord.
Offense. Injury.
Injury simple, my lord, at page 56. 36. And front offense, simple.
Why it was taken up, na? Morning?
Morning, yes.
What happened?
Affidavit.
On the side of the informant, nobody was
Already.
that is why
Lipun is the injured. Right. And we say the opposite party number 2. Fire number 2.
Ganesh Vishwa.
The allegation against the allegation in the FIR made against that that Parature, the petition of Parature, that informant that is on 21/5/2017 at about 9 p.m. The informant's son, that is opposite party number 3, had gone to a Bharat party in the village Brahma Mandi, and it is alleged that the petitioners in an intoxicated condition abused in the Hindi language to the opposite party number 3 and threatened with fire consequences. The opposite party number 3 was also beaten up by the accused person. And beaten by the accused person by Jug Road. By the second Jug Road. This was Jug Road and Beer Road. Jug Road and Beer Road. The parties have settled the issue. Where is the injury report?
My lord, I said 36.
36? Yes.
Of injured people.
Injury report dated, and the petitioner, the opposite party number 3 was subjected to medical test, and the injury report indicates that the injuries are simple in nature. The petitioner and the opposite parties have settled the dispute, and on the basis of the settlement, the petitioners are seeking indemnity of this court. Next, the parties have filed their the petitioners and opposite party number 2 and 3 are present in the court, being represented by their counsel and identified by them. They also filed a self-restriction copy of their Aadhaar card, which are taken on record for establishing their identity. Next, the parties have filed affidavit dated doing part of the justice, stating that on the intervention of the witnesses, they have to settle their dispute, and opposite party number 2 and 3 are not interested to prosecute the petitioners. Mr. Maharaj appeared for the state and suggests that since the parties have settled their dispute amicably, filed the affidavit before the court. There is no legal impediment for affidavit before the court. Since although the offense after under alleged offense under 307 offense under 307 IPC has been alleged against the petitioner, but the injury sustained by the opposite party number 3 being simple injury, the court can give indemnity to the petitioner and require the FIR. Taking the petition was subject to the petitioners. How many petitioners are there?
3 petitioners.
Subject to the 3 petitioners. Each of the petitioners paying rupees 1,000 cost to the injured opposite party number 3 during the course of the 3,000 rupees paid. 3,000. Yes. And file the receipt.
Mail.
55.
Yes, my lord.
My lord, one of bail rejection order, my lord. by the Land Court Sessions Judge Khurda, my lord. The quantity as mentioned there, my lord, 22.22 kg, 532 gram.
What was the matter? What was this matter? Yes, which was that order you? The petitioner is agreed by the condition imposed by the court below, while allowing his application under 457 CRPC, while order dated 19, order dated 13/11/2023. 13/11/2023. Right on. Next, the petitioner contends that petitioner is an accused in FIR number also. Napoli PS case number 159 of 2023 under section 20 small b small Roman 2 and small c of NDPS Act. He was apprehended while carrying 22.53 kgs of contraband ganja in the auto rickshaw, which was seized. So next order, he moved an application for interim custody, interim jima of the said auto rickshaw. Although the trial court allowed the application and allowed the application and directed to release the auto rickshaw in favor of the petitioner, but the trial court imposed condition number 7. That petitioner is a board man and he was involved in the previous case. He was transporting ganja of 22.53 kg, and of the pension review that the condition imposed by the court below is onerous one, hence it is modified. The petitioner in place of the condition number 7, the petitioner is directed to furnish indemnity bond of ₹1 lakh. Indemnity bond of ₹1 lakh, and this property security and cash security is done away with. Allowed. Done away with.
Pardon my lord, item 33, I only want to permit to surrender and dispose of in accordance with law. Item
33, what happened? Let us for the petition 33. Let us for the petitioner seek to withdraw this petition with the liberty to him to appear before the court below and seek appropriate remedy under law. On instruction, petitioner counsel for the petitioner submits that inclined to appear before the court on or before 30th of May 2024 and availing all remedy under law. With this liberty, the petition is disposed of.
The
matter was before Lordship's day before yesterday, and Lordship directed the parties to come, and all have come today. Present, my lord, in court.
Yes. Mr. Raghunath, just check it.
Aadhaar card. Affidavit already filed.
Again, copy देंगे आगुरी फाइल इन्फॉर्मेट हो जी जयंती प्रधान
Who is the victim? Chintu.
Jayanti Pradhan, my lords. Informant.
Who is this Chinmay?
Son of Jayanti Pradhan.
He is the informant.
Chinmay is the my lord.
What is his role?
In the FIR, my lord, allegations were made against Jayanti as well as Chinmay. So both of them have been made as parties.
The FIR is registered by Jayanti against the petitioner.
My lord.
Why you have implicated Chinmay?
Because some allegations were there.
These are the victims.
Victim, my lord.
That's
Victim.
what I'm asking.
My lord.
Allegations are made against both.
My lord.
Right on. Who is the author of the FIR?
Mother.
At the insult of opposite party number 2, FIR number 2, so him to register against the petitions. It is
Informal. Understood.
It is alleged in the FIR that on 5/8/2019 at about 8:35 p.m. a quarrel had to be taken between son of the informant, maybe between number 3 with the petitioner. Petitioner number 2 suddenly attacked the opposite party number 3 and abused him in slang language, and then also threatened to kill him by means of gun with gun. He was accompanied by other accusers. On the basis of the aforementioned allegation, FIR was registered. In investigation, charge sheet was filed on 24/10/2019. 24/10/2019. 24/10/2019 and 19. Before the trial to commence, the parties have settled the dispute and the petitioners have filed the petition for seeking question of the FIR. Where is the affidavit?
Madam, we have filed.
Already flagged. Where is the affidavit? The joint affidavit dated 5/5/2023 has been filed by the fathers. Entry they are stating that they are neighbors or what?
So, good side or yes, madam.
They are stating that they hail from the same street, belongs to the same street, and to maintain peace and tranquility, they have settled the disputes, and the opposite party number 2 and 3 are not willing to proceed with the petitions. All the petitioners and opposite party 2 and 3 are present in the court, being represented by the respective counsel and identified out them, other card and all. No? That's all. Mr.
The joint affidavit filed by the opposite one note 3 and one of the petitioner.
Ragada appearing for the state submits that since the parties have settled the dispute and joint affidavit by petitioner number 2 and 3, opposite party number 2 and 3 and petitioner number 1 have already been placed on record. Interly stating that they have settled the dispute. The offences are minor in nature, so therefore there is no legal impediment in passing the FIR. Taking into account the cost. Yes, how much cost you will pay to the informants? How many accused are there? How many accused? 2 accused?
3 accused.
3 accused. 2,000 each. Subject to all the petitioners pay cost of rupees 2,000 each to the informant and the
2,000?
6,000 pay.
The affidavit, my daughter may say, the affidavit shown by petitioner 1 and opposite 3.
No, they have filed joint affidavit filed by the petitioners and opposite party number 2 and 3.
Opposite one 3 and petitioner 1.
It is written petitioners.
Petitioner
ठीक है
petitioner 1 and opposite 3.
The cost is reduced.
pay 6,000 rupees right now. Huh? And give the receipt. Then only it will be approved. Some କହିଦିଅନ୍ତୁ 6,000 ଟଙ୍କା 6,000 ଟଙ୍କା ଆପଣଙ୍କୁ ସେମାନେ ଦେବେ ଦେଲା ପରେ ଆପଣ କହିବେ ଆସି ତାପରେ
Deeply.
କୋଉଟା
59.
My Lordship, on behalf of Samrendra Bahadur, it's a Belgium matter. My Lordship, petitioner was released on bail on 4/7/2017. And NBW was issued on 12/12/2022.
22
Yes.
500 each.
Let's say both are women.
There are two.
Yes, both are
61.
obliged.
My lord, NBW issued on 27/4/2023 and earlier bail was granted on 13/9/2016.
ଏରିଆଟା ଦେଇନାହାନ୍ତି 10,800 ଟଙ୍କା ଏରିଆ ଦେଇନାହାନ୍ତି
କୋଉଟା area?
ଦେବେ
ଷାଠିଏଟା କହୁଛନ୍ତି ଷାଠିଏ
ନା 61.
60ଟା କଣ
ସେଥିରେ withdraw 13/9/16 bail NBW
Issued on 27/4/23 page 27.
Yes.
62.
Petitioner was released on bail on before trial for 21/7/2023 and NBW has been issued 27/2/2024. 27
equal installment ଦେଇନାହାନ୍ତି ହାଇକୋର୍ଟ ଅର୍ଡର ଡାଇରେକ୍ସନ ଦେଇଥିଲେ equal
ଯାଇ କରିବେ whatever. 500.
63.
May I please, Lordship? Lordship, a Belgium matter. The petitioner released on bail by police on 8/6/2018, my lord. And NBW was issued on 24/2023, my lord.
500. 500.
44 NBW 44
64.
Belgium matter. Petitioner released on bail 12/3/2018. NBW issue on 26/11/2018. 18.
1,000.
Obliged.
65.
It's a Belgium matter, my lord. NBW issued 17/11/2022, my lord. And the petitioner was granted bail in the court below 28/8/2017.
17.
Mine.
500. 2,000. No, 1,000.
No, my lord. NBW issued 17/11/2022.
22.
Mine.
warrant out 22 yes
500.
Deeply.
66.
May I please, Lord. The NBW was issued on dated 5/9/2023 and he was released on bail on dated 24/3/2020. 2020 granted bail and NBW was issued on 5/9/2023.
500.
Yes.
67.
May I please, Lordship? Lordship released on bail on 4/1/2022 and NBW was issued on 22/11/2023, my lord.
500.
Obliged.
68.
Belgium matter. Order of NBW dated 31/3/2023.
41 is 41 is
41 is. And police had issued notice at the 41 and that was fine.
ତାପରେ bail out by court ଲେଖା
Before.
sentence second paragraph 500.
Yes.
69.
May I please, Lord? This is Belgium matter, my lord. Annex 3, page 23, NBW order, my lord. Release on bail on 4/3/2020, my lord. Annex 2, my lord.
Yes.
4/3/2024, NBW.
4/3/24
4/3/24.
500.
71.
NBW dated 11/8/2017, my lord.
71.
Yes.
It's 70.
70.
It's 71.
70. Item 70.
Yes. What is this?
Absconder and below. Arjun,
Why Arjun?
NBW 19/12/2023. Charge sheet 5.1.
He has been absconding.
Abscond.
The charge sheet was filed
Yes.
against the petitioner showing him as an absconder.
No, charge sheet is absconder.
Oh.
Charge sheet file is 5/1/2024. NBW 19/12/2023.
Thereafter he is absconding. Now he is
Absconder.
right. Absconder means charge sheet was filed. He was shown as not arrested. Not arrested. Right. Right. The petitioner was on bail. However, the charge sheet was filed showing him as a not arrest. Subsequently, NBW has been issued against him on
19/12/2023.
Yes. By court of same 500.
May I beg to pardon, my lord. Item number 69, my lord. Petition number 3 is already arrested, my lord. Or petitioner, my lord. Petition number 3 arrested, my lord. Petition 3 not pressed also.
3 not pressed.
Oh. Item 69.
69.
71. Present petition. While the petition number 3 is not pressed.
May I please your lordship? 71, my lord. Petitioner was on bail. But NBW issued on dated 11 August 2017, my lord.
11/8/2017 NBW. Bail hela 15/12/2016.
1000.
11/8/2017.
10. 1000.
72.
My lord, NBW was issued on 9/2/2022. Offense alleged to have been committed by the petitioner. 138 NA Act. 205 petition was allowed.
Forget about NBW was issued on 9/2/2022.
Yes.
This matter is the writing part of the complaint case under 138. Same out of 500.
73.
May I please, your lordship? My here the case law that impugned orders page 34 and the operating pass page 35. The latter lordships can tell to page 35.
NBW issued.
Yes, Lord. On the request of the IO.
You are absconder.
Yes, Lord. No.
Absconder. Charge sheet was filed in the present case. Petitioner is accused in FIR number 2. And charge sheet was filed showing the petitioner as an absconder. On the request of IO, NBW has been issued against the petitioner
on 7/2/2024.
On 7/2/2024. Same out of
One line, your lordship, observe, Lord. One line. The sum of the meantime, some of the co-accused person are listed. Some of the co-accused person already granted. That the village.
Not for the petitioner submit that the other co-accused persons have already been granted bail, and he move application seeking parity.
Deeply obliged.
74.
May I please your lordship, my lord. My lord, the NBW was issued and dated 26/4/2023. Petitioner also granted on bail dated 14/5/2013.
500.
Obliged, man.
75.
It may please your lordship, this is a 138 case. I am supposed to file the complete requisites, but I failed to file the acknowledgements. Today itself, I have filed the acknowledgements, complied everything.
Submits that he has filed the requisite today.
So notice be issued and interim order to continue. Interim order to continue.
Yes.
76.
Yeah, last time your lordship has kept it for order reserve. You know, order as petitioner has paid for time.
Today, I have to place my case. I brought two decisions. Lord Simesi, well covered.
So that society matter.
ଆମ ପାର୍ଟଟା ତ ଆମେ ସାରି ଦେଇଥିଲୁ ରିଟର୍ନ ନୋଟ ଦେଇଥିଲୁ।
Yes.
This is of Karnataka High Court. Para 3. Para 3.
Yes.
The present respondent as a complainant has a filed private complaint under section 18 of that Karnataka Protection of Interest of Depositor Act before Special Court for the offence punishable under section so and so, alleging that the present petitioner who is in charge of Sangoli Rayat Credit Cooperative Society, also Gajraj Credit Cooperative, has failed to refund a sum of 66 lakhs 27 lakh to the various depositor who had deposited the said amount with the said cooperative society. This fact also same. Para 7. Only I have brought the fact. 7. The learned counsel appearing for the petitioner in his argument mainly canvassed a single point that the definition of financial establishment are defined under section 2(4) of the Paid Act excluded cooperative society controlled by the state, since the society of the present petitioner are controlled by the state, the Paid Act is not applicable as such entire proceeding. That was the submission. Here also similar submissions. But then section 2(4) of that act was put last of that page towards last.
Yes.
Which is parameter provision of 2 hour of paid day.
Parametry.
Miller. Then para 10. A reading of the above the definition shows that the definition of some financial instrument does not include a cooperative society which is either owned or controlled by the state government or the central government. In the Eastern case, what is to be looked into is whether the petitioner society, which is said to be cooperative society, registered under KCS Act.
Once it is registered under KCS society, it's controlled by the state.
Yes. That
is what?
Finding Miller.
Yes. No, it's all right. It says once it is registered under the society registration act, it is controlled by the state. Therefore, it is a final settlement.
As far as my submission is concerned, as I have completed, I stick to that one. I have submitted my written argument. More part of the last time you
have to deal with this. This judgment is direct.
Okay, I may be given a copy of it. I will give my written submission.
Judgment
already submitted the written submissions.
Judgment
Government, I have submitted a written.
Judgment
Within 7 days, I will file my written note. Also, my reserve, I will 7 within 7.
Keep this judgment in this file.
Thank you.
Yes.
77.
May I please, Your Lordship? Let's the two affair, the same incident.
These for units. Euro. Only put low here. Yes.
Well, let's.
Which one?
77.
May I please, Your Lordship? Let's the incident was one, two affair. First affair is the tenant. And second FR is the landlord, my lords. Lordship order dated, lordship may order number.
Which one is correct?
My lords, two cases they have filed charge sheet, my lord. That I have also filed a charge sheet, my lord, flag B. My lords. That first case is only for the arising out of civil dispute. It was also reflected in the charge sheet, my lord. Lordship may kindly see the order dated 6/2/2024. Then my lordship was issued notice, but they didn't appear. Then my lordship also directed to notice, sir, through police.
Through police
But
and
they-
short, my lord.
Short, my lord. But
Short, my lord, so far the first case is concerned, my lord. She left that place, my lord.
Yes.
Regarding the rented house, she left that place. For that reason, could not be sharp upon her, my lord. And second case, my lord, the notice.
notice, sir,
through
my
police,
lord,
my lord.
that through police, sir.
What happened in this case, my lord? Last occasion, my lord, Mr. Kishore Mishra, my lord, appearing for the informant.
One case, my lord.
One
And
of
he
the
seek time for the.
1160.
But
He has not appeared today,
that
my
is
lord.
different thing.
That happened, my lord. So far, these two cases are concerned, my lord. One lodged by the house owner, another lodged by the tenant, my lord. But there are two parts the occurrence, my lord. Both the cases are correct, my lord. As because, my lord, the first part, initial part, my lord, these three accused persons enter into the house where the tenant residing, my lord. Outrage their modesty, damage the CCTV and vehicle other matters. For that, abuse or till now, that is their, my lord. Here is such hola when the owner residing side by side, my lord. When the owner came there, they also abused the owner. For that is another case. Two I was, my lord, in which case, and two cases, both the cases, charges submitted, my lord.
It should have been one case.
No, but there are two. But first, my lord,
Two different houses.
two
No,
parts
one
of the
house.
occurrence, my lord. First part, my lord, those same time, my lord, two parts. First part, the accused person enter inside the house. The occurrence technically inside the house where the tenant resides, and they assaulted and outraged her modesty. Hearing such, my lord, sound and about the quarrel, my lord, when the owner came there, these accused persons again abused her and assaulted. That is the case, my lord. There are two parts of the occurrence, my lord. Both cases will remain, my lord.
Same
And
time.
trial will face.
Same.
If you will file petition, then both cases.
I will direct to the trial court to proceed.
Lordship, my kindly similar. The lordship has left, already has already left the house, my lord. Lordship, that the first case is concerned, the tenant is concerned. If the FIR is, my lord, true, then police has not been shot till now, my lords. Even if, assuming for a moment, my lord, charge sheet, even if charge sheet has been filed, but lordship is to notice that it didn't turn up, my lord, till date, my lords. Lordship, where the house owner is concerned, he has also not been able to inform to that person, my lord, because he already left. Now, my lord, this incident is concerned, only 5 minutes gap, my lordship may kindly indicate that lordship's order 6/2024. Lordship may kindly for a moment. Let's say that kindly for a moment, that 6/2024. Only the second paragraph. Incident was same day, time is, my lord, 10 p.m. And that, my lord, the another is, yes. No, that my lordship may kindly see the FIR. First, my lordship, that page 13 for a moment, my lord. Annexure 1, page 13, first FIR. 3/2023, that 23:15 hour.
That I have seen. That
Yes, yes. But lordship may see
that he has explained now, Mr.
No, that is the issue, my lord. The arising out of civil dispute. Lordship may kindly for a moment that the charge sheet, the lordship flag B for a moment, my lord, flag B.
Outraging modesty civil.
Yes, my lord, that is that is arising out of civil dispute. The occurrence has been took place. That is reflected in the charge sheet. My lordship may page 12 of my charge sheet.
I don't know intention and all. Because
charge sheet has been submitted.
On 6th of February 24, I
Yes.
issued notice
Yes.
recording the fact that this is the same incident.
Yes.
And two FIR is registered.
Exactly.
Then I have been asking one FIR may be correct, another is not.
Yes,
but he has explained now.
Since charge sheet someday both the cases, I came to know this.
That lordship may for a moment will page 12 for a charge sheet, my lord. What they have stated, my lord. Let's see the second paragraph. That is indicated, my lord,
page
12, my lord. Even if charge sheet, as police has been committing the charge sheet, but here is the land dispute. It is very, my lord, very clear that somebody has sold the land, somebody has purchased the land. Only because of civil dispute, this FIR has been lost, my lord. But nothing has been stated. My lordship, FIR, for the sake of argument, my lord, the FIR is indicated the totally same thing, my lord.
Witnesses there, eyewitnesses are there.
Witnesses, but if your lordship may, for assume.
You argue that at this stage of.
My lord, both cases.
No, lordship may.
Where the petitioner seeks to withdraw this petition.
No, lordship will.
To argue all the available, all the points at the appropriate stage.
No, lordship, framing of charge.
This liberty, the petitioner.
Lordship may indicated, my lord, at the time of framing of charge, my lord.
Yes,
Lordship,
at the time
the
of-
framing of charge, my lord. Otherwise, my lord,
Yes.
the appropriate stage, lordship, difficult.
Any urgent matter?
Both the cases.
Very urgent matter.
My lord, item number 89.
One after another.
And my lord, lordship, one, lordship may only frame. Lordship, if all the points have raised before the learned court below, my lords, at the time of framing of charge, same shall be considered in available materials and record. Lordship may kindly indicate. Lordship may kindly on the record. Indicate it. Great, my lord.
They are there.
Asina de.
Rest of the matter will also next week or after vacation.
Next week.
Rest of the matter is
Next week.
No, it will be there.
My lord, item
My lord,
105.
item number 89.
Monday,
85 is the modification.
Monday, these matters will be. in-
My lord, what I want to submit, my lord, another CRLMC has been filed where it is listed D CRLMC, so not yet confirmed. So it will be tagged up because the same matter is same. So 105 maybe after
And that day you say. 105 urgent.
2 weeks after us. 2 weeks. 105 should.
Wherever they ask me for adjournment, give it.
Okay. 105 after
Late filing of requisites, my lord. Item
Okay.
90, late filing of requisites, my lord, accept it and let notice you go to the office.
102 after
90.
notification is given.
My lord, I am in BC.
Modification, my lord.
Which one?
Item 92.
92 modification. Allow for the modification. You want extension of time?
Yes, sir, extension of that.
92.
85, my lord, modification.
102 after vacation, my lord.
My lord, 100. See, what was the order?
102.
Petitioner was directed to appear before the court below on or before 10th April 2024. And we remedy on the law. Extension of time for the 30th May. 30th May.
My lord, item
Item 90, my lord.
Pardon to make a
Item 90,
mention, my lord.
19 interim order to.
Entry also nahi. Notice has to go to opposite party because of the fact that I filed the cause title that has let it be accepted because during the process of that filing.
My lord, item 100.
My lord,
Interim
I
order
am
to
in BC,
continue
my
and
lord.
let it after vacation also, no problem. Interim order to
No,
continue.
no, we'll see. Let it be on Monday. Monday.
ସବୁଗୁଡା